You may be seated. Court does call the case, People versus Desmond Campbell. Sir?
You turn it.
Oh, got it. Go ahead, counsel.
Good morning, Jeff Perlman on behalf of Desmond Campbell.
All right. Your name, sir?
Yes, Campbell.
All right. Okay. This is date and time set for sentencing. Have you reviewed the pre-sentence report?
Yes.
Yes, Judge, I have, and I have with my client.
All right. Are there any material deletions, corrections, or additions to the report?
There is, in the last indication on his previous record, that's not him. It must be somebody else with a similar name, but there's an indication of a felonious assault. That is not him. Otherwise, everything else is accurate.
You're talking number 7,
Yes.
Wayne County. All right. Got it. All right. Anything else either of you'd like to say before I do impose sentence?
Just that my client is a very hard worker. He's, on a good track. He did take responsibility and has learned a tremendous amount from this situation. We are asking respectfully that the court follow the recommendation of a 12-month probation.
All right. I do have before I go to sentencing, I do have a community corrections violation. Is that correct?
So it's my understanding there was a violation. However, my client has since obtained a medical marijuana card, which I think perhaps would address the violation.
Okay, this was the one that was sent through. Correct.
Yes.
That's the one. Okay. So he doesn't have the card yet, but the application and acknowledgement of the application and card came through. I think that's what we received.
Okay, I believe is that accurate, Mr. Campbell?
Yes. Yeah.
Okay.
Probably could have done that before. All right. Anything you want to say, sir, before I impose sentence?
No, sir, I apologize. I just want to handle this and get it behind me. That's all.
Sentence of the court, I'm going to place you on 12 months probation. You're going to pay $655 fines and costs, $360 probation oversight fees. When can you pay that?
I can start in a couple of weeks.
Pardon?
I can start in a couple of weeks.
You have anything today?
No, sir.
All right. So are you asking for a payment plan?
Please.
All right. I'll do it. A payment plan as arranged by probation. No use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a gun safety class as directed by probation. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will order the forfeiture of the weapon, which is the Taurus G2C with the serial number as in the file. I'll order that you maintain employment with verification to probation. I'll order 365 days in jail. Credit 2. The balance is suspended. All right.
Yes, sir.
Thank you. Thank you,
Thank
Mr.
you,
Cole.
Judge. Have a great day.
You too.
Thank you.
Court calls the case. People versus Dustin Megison.
Good morning to your honor and to your staff. May it please the court, Joseph Slavin, P number 61705, on behalf of Mr. Megison, who stands to my right. Sir, could you state your name for the record, please?
Dustin Megison.
Your honor, we've had the opportunity to review the pre-sentence investigation report. We find no additions, corrections, or deletions that need to be made there too. Just brief allocution.
Okay. I have a bond violation. Were you aware of that?
I was not, your honor. What's the bond?
That's also set for a hearing today. It appears to me that he operated a vehicle without Security.
I was not aware of the, was there a no insurance, someone?
Yes, I had been pulled over for. I didn't get no ticket for it. I didn't get no tickets, and I didn't get arrested.
It looks to me, counsel, and I will
I got pulled over.
tell you what I'll do so that you have all of the information. I'll pass the matter and then have my staff give you a copy of this report. So that,
That's, I don't have that.
okay, so I'll pass this matter. Go through that with your counsel, your attorney. Sir, go ahead and have a seat. Court does call the case People versus Brenda Miles Roberts. Like, so.
I can email the court if you want to just pass it.
Okay, so what kind of payment plan do you want? So are you asking for a payment plan?
Please.
All right, I'll do it. The payment plan is arranged by probation. Compliance with recommended treatment. So therefore, the sentence of the court, you're placed on probation for a period of 12 days.
I think it might have been just.
Yes.
Or
She'll talk boss.
set aside the last bench warrant. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $15,000. I give a 10% privilege. That warrant will issue immediately. Court calls case People versus Christopher Fair.
Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Fair.
Not checked.
Christopher Fair. It's also a show cause.
Yes.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. 10% privilege. Warrant will issue immediately. Court calls the case of the People versus Jacob Hodge.
Good morning. Oh, Joshua Hodge.
What did I say? I said I have Jacob. I think it's you guys anyway.
Yeah, Jacob Hodge, but it is a me.
I didn't call this one. Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Hodge.
Not checked. We don't have her. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500. So give a 10% privilege on that. That warrant will issue immediately. Court does call the case People versus William Kendrick. The keys.
Morning, I'm hearing it about Mr. Kendrick. Get your name, sir.
William Kendrick.
Thank you, sir.
I spoke with Mr. Kendrick yesterday. He informed me that he was incarcerated in Washington jail for 30 days in May. He lost his job. He is looking for a new job. So I got some permits to give him time to get back up the start date.
I'll adjourn the show cause with my October date.
October 14th.
October 14th, 2026, 9 a.m. All right. Thank you, Mr. Kendrick.
Thank you. That's my birthday, Your Honor.
Is it?
Yes, sir.
All right, so hopefully people will give you money for your birthday and you can come in and pay us.
Okay, yes, sir.
I know that's bad, isn't it?
All right.
All right, Mr. Kendrick, you take care.
Y'all have a good day.
You do the same. Court calls the case, People versus Evan LeBron.
Good morning, Assistant Public Defender Laura Perry on behalf of Mr. LeBron. Patrick. Mr. LeBron yesterday morning, the Zoom link, I don't have an explanation.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $5,000 to 10%. That warrant will issue immediately. Court calls case of the People versus Lorianne Pearson.
Good morning, Assistant Public Defender Laura Perry on behalf of Ms. Pearson. We're in my court, she paid off the balance.
I have it at 0. I do. All right. She told me she was not paying full. Defendant paid, she was canceled. Court calls case People versus Dallas Williams. So show goes.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Williams.
Dallas Williams. He's not here.
Your Honor, I did speak to Mr. Williams this week about the show cause hearing. I do see that he made a payment on the 11th, because he told me he attended to do. Although I cannot explain his lack of appearance here today, I do know we spoke. He did attend to appear, and he did make the payment as he indicated he would. So I would be asking for the consideration of an adjournment.
Well, when did he make a payment?
My court said, give me 1 second. My court said yesterday, 8/11,
How much?
a $50 payment.
Well, the last time we were here, February, he was to begin to pay $100 per month beginning March. And then I said that if he paid the $100 per month, court would consider waiving the $650 bench warrant fees once $1,000 had been paid. And I adjourned it out to May 13th, which I think got pushed to the 27th. I then adjourned out that date to August 12th, today, 9 a.m., and I set that in person. And he's not here, and it's only made a $50 payment.
I understand, Your Honor. I do remember the last time we were here, he was just returning back to work after a serious injury. So, like I said, I did speak to him. He did make the payment. I cannot explain his lack of appearance here right now. However, I would still be requesting that adjournment.
Bench warrant will issue bond set in the amount of $15,000. They'll give a 10% privilege. That warrant will issue immediately. Court recalls case People versus Justin Megason.
Right. Your Honor, again, Joseph Slavin, P number 61705 on behalf of Mr. Megason. Your Honor, I did have the opportunity to read through the statement. There was no citation issued. There was a glitch. I did talk to Mr. Megason about what was the deal with the insurance, and he showed me his insurance card, and it is valid insurance now. What it was is he gets paid, he gets direct deposited, but he has his account set up for the automatic payments for the Progressive, and payday and Progressive Day lined up the wrong way on a particular occasion, which means that payment didn't get processed. And if you're on a payment plan to pay your insurance, they just can you right there, like, okay, no. So they had basically shut it off. He didn't know. And this actually is what gave him the knowledge to call him Progressive and say, okay. And then he corrected the error, made the payment that was missing. they reinstated his insurance policy. But other than that, there was no citation issue.
Do we show anything regarding him?
That's what I was curious.
State police.
Don't see anything open for him.
No. I think, and it says in the description that when the trooper, got his license and everything, and that it says that he conducted the stop and realized that he was on bond. So I guess he just thought it would be a idea, because he asked a lot of strange questions to Mr. Megan. He's like, "You doing any heroin? No, you doing anything?" I don't do any of those drugs. I think it might have been just, he says, "Oh, his eyes were bulging out." And it's like, no. And he's done testing here. He's never tested for any substances. So why he took it upon himself to just, I guess, write a letter, making it look like some kind of a report, but it's really a report of nothing. They did impound the vehicle, which they got the vehicle back. The only thing they found in
Were put under arrest?
They did put me in the handcuffs, but then I contacted my attorney. I don't know if my attorney got a hold of them. And that's when I got released.
Yeah. Him and his
At the scene?
At the scene. Me and my mother both got released at the scene.
Who?
Me and my mother both. My mom.
They found a circular saw and a couple of bottles of pop in the car, but
Hold on a second.
nothing else.
You're riding around with your mother?
He had just got off work. I was on my way home that night.
The only thing he was given at the scene was the business card for the trooper about where the towing is. And
Why am I have a 4-page report about operating without insurance. He put up, he's with his mama, and then there's a line that they request I violate his bond on this case, which has nothing to do with driving.
no. And I think they might have charged it.
No,
My guess is that they saw the charges that were pending against him and thought, oh, okay.
I don't know what to guess. Well, that's a good guess. I don't know what.
I think it's you want to mess with the police officer? Maybe the police officer might mess with you back.
He gets put in handcuffs. I get a 4-page report to violate his bond. So I think that's discretionary then on my part,
Very much so.
right? So I could or I couldn't. I don't understand. He's with his mama, right? Now, if he had been out running around every place, and I get that, well, the last line reads, second to last line, I respectfully request the 14th District Court violate Dustin on bond because he was operating a vehicle without security. Submission.
And he should have arrested
Yes.
for the misdemeanor on this
It's
thing.
absolutely a misdemeanor.
It is.
On it did, then they issued citation. They didn't issue the citation. So I respectfully decline to violate his bond. I just don't see it. I don't need.
Don't see it either. And I do think it's a little bit of a waste of resource or tax dollars to send this kind of report in time just to try.
It's just another tree. To me,
My great
I'm not,
won't be able to climb trees like I did when I was a kid or build forts because there won't be any trees to do it with.
maybe not. That's no.
But-
Now you got a copy of the report. You can save that.
Well, then I get
Right.
some of the, yeah,
All right.
I'm going to give that to you.
All right. With reference to the sentencing.
Sure. Your Honor, before you, Mr. Magnuson is a hardworking guy. He works 40 hours a week. Matter of fact, he works with his mom. That's where they were coming from that day. And, he's a high school graduate, do some ITT tech and still looking to get that job here in the Capitals. But right now he's said, you know what, you do what you got to do in the meantime. And he doesn't have any history. He self-reported. The PSI clearly states that he doesn't have any substance abuse use disorders at all. He maybe drinks twice a year. So does he have a past? Yeah, like from like 7 years ago and a little bit further, some driving on suspended licenses. And that's why he's, having that license was important to him, because he finally got that license and everything and got his license all squared away. And he's not that younger guy anymore. He's just asking that, and we're not downplaying the seriousness of the whole incident, but we just ask that we adopt the recommendation.
Anything you want to tell me? No? So he works with mom, drives around with mom, and want me to lock him up. I don't get it.
He lives with his brother as well. They have a very close-knit family.
Apparently,
No, yeah. I know a lot of families who I'm like, they don't talk, and instead, you grow up close. So,
all right.
We just celebrated a 90th family reunion like a couple of weeks ago, and it's really cool. So, for me, I don't know. I grew up from a big family, so
all right, Mr. Mickelson. Sense of the court, I'm going to place you on 12 months probation. You're to pay $555 fines and costs, $360 probation oversight fees. When can you pay that?
Can I put on a payment plan and I could have it paid off within maybe 2 or 3 months?
Can you get it paid by October 30th, you think? Do you have anything today?
I do not.
Why is everybody not showing up with money? You know what? Richard, mom showed up. Mom would have money.
She's actually off of work right now because she just had surgery.
Yeah, okay. Well, wish you the best from us. All right.
Thank you, Aaron.
I'll indicate that it's a payment plan as provided by probation, but he's to have it paid off by October 30th, 2020.
Thank you.
No use of alcohol, recreational marijuana, or any illegal substance will be subject to random testing as requested by probation. You're to complete a substance abuse assessment, follow all treatment recommendations for status reports to probation. You are to complete a behavior modification class. There's to be no assaultive, threatening, or intimidating behavior. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. I will order 365 days in jail. Credit to the balance is suspended. Great.
Thank you, Aaron. Have a good one.
You do. Here.
Three additional person. Email.
Okay, that goes to probation.
I shared
Yeah.
that. I shared that with probation.
Court does recall the case, People versus Brenda Miles Roberts.
Again, good morning, Your Honor. Robin McCoy on behalf of Miss Brenda Miles Roberts, who stands to my right.
Your name again?
Miles Roberts.
Thank you. All right, good. We had read the pre-sentence report, no material deletions, corrections, or additions. Anything two of you'd like to say before I propose sentence?
Yes, Your Honor, just by way of explanation. So my client is gainfully employed. She also has her own separate home care business. This is her first time ever having a drunk driving situation. So she's very remorseful about it. Her mother passed away on June 30th. So that she had been grieving and had time off of work. I did notice the violations, and she had explained that for the July 30th violation, her daughter was going for her first college to go to Wilberforce. So that she said August 4th was her first day back to work. I would note that all the tests as far as the payment, she said she'll need till Friday to make that payment of the 264 because that's when she gets paid. But this is her first time having, but we are requesting that she be given the opportunity to, if not, or just discontinue with the sober link, or at least have a reduced time, come back after she's had a period of compliance and come off the sober link. We also provided a verification that she did comply with for the MAD, the Mothers Against Drunk Driving class, and the sober link listing, which we emailed to the court and Ms. Pilar. So, and did you want to say something to the court? She does want to say something to the court.
Yeah, the time I was wondering for the times that they were saying that I missed. I'm going through a lot right now.
I read the report. I'm not concerned.
Oh, okay. I just wanted to make sure because I just went back to work and I work in the doctor's office. It's kind of hard to be going back. I can be I'm a surgical assistant. So if I'm in surgery and my alarm go off that I got to blow, once I get out of surgery, I might forget. It's just too much. If it was something different, I'd do, but I can't, that blow thing is, I got a lot going on with working in a doctor's office. And that was it. I just wanted to let you know that is, I'm going through a lot right now. I'm going to grieving too about my mom with my insurance company, my medical insurance and everything. So there's a lot going on in my life right now. Besides all of this, there's a lot going on.
And how's your daughter doing in college?
She's doing great and she's loving it. And I'm really alone now because it was just me and my mom. So my mom gone, it's just my daughter gone. So it's just me.
Yes, Teresa Claire on behalf of probation. Your Honor, I just wanted to let the court know that Ms. Miles Roberts was scheduled for sentencing earlier. But my office had to bump that out because there was a possible restitution claim. So she kind of already has gone on the sober link for an extended period of time because I did have to adjourn that for a possible restitution issue. I never received any follow-up from what was initially sent. So therefore, there's no restitution recommended in the case.
Got it.
Okay, but I just wanted the court to be aware that
she was on it.
An extension of time because it had to be adjourned to
Sam's right there. This is just a status check, Your Honor. This is someone who's been on probation. She's owed a lot of restitution. We check back about every 6 months just to make sure she's still paying, and she's still paying. So
Is she still paying?
She
Good.
is.
Well,
The only thing was
Oh.
February through May, she didn't make any payments.
she has a financial trouble.
who does?
Oh, I know, but it was.
What's the balance on this?
The remaining balance is $69,713.
She's paid.
She's paid $55,287.
So where are we?
Just still making payments, trying to get that. She's on a non-reporting probation. She's this is being held over just with the verification. It's not a full case. So it's just a matter of.
And she's paying at a rate of $500 a month.
Yeah. So she's.
So that's 6,000
Yes, sir.
a year, and how much is left?
$69,700.
That's still 12 years to go.
She pays when she can pay more. She's been paying more, and then I know for a while there she had kids in high school and it's home, but now she's an empty nester, I guess now. Well, very college. I guess that's just bad. Well, what I'm getting at is getting her expenses are should be getting less than they were in the past, and which means she can make more payments as time goes on.
Okay. This was something that occurred 20 years ago.
Yes.
And
She's on probation for 10 and has it in now.
I know, but I don't feel sorry. I don't have any, I have sympathy for Mr. Humphrey, who was a very benevolent man. When he worked hard for what he made, and he was very successful for what he did. But this has been 20 years, and the thing that is on restitution is we don't order what in some states they do, what ought to be done, and that is the restitution plus interest, because you're just playing dollar for dollar. This is like when you took the money, it's like a no interest loan that you're paying back on your term. All of that's not right. I mean, you shouldn't have done it in the first place. You should have paid it back as soon as possible. And it's somebody's out 6 figures and all of this. What was the total loss? It was 125,000. And still, we got 10 years to go at this rate. Still, we should live so long. You know, I'm railing on, but it's just not fair. And the problem is the door is open, and this is the way it is. I just wish we had interest added on to it, which would make it more fair for the victim. But they're getting on your terms. When you decide you can pay dollar per dollar, and it's already taken 20 years, and you're still only halfway through. I just don't see fairness, which is what we do here. People make mistakes, then you fix them as quick as you can. It shouldn't take 40 years to fix it at no interest for the loss, dollar for dollar. The way costs what money is worth 20 years ago, it's reduced significantly. So you're ordered to pay how much a month? How much?
I should write down $500.
Okay. And your income has not changed since the last time we met?
I've got one in college, and I don't have the other 2 obviously living with me. But income has gone up a little bit, but yes, I can start paying a little more. Earlier this year, I had my daughter's car. And have somebody else. Well expected.
I paid my way through college. Every dime. All my education was paid by me. Undergraduate, graduate, and law school. My parents never paid anything. But the person who's in school that you're paying for, they don't have a job or something?
She works part-time at Market Basket, which pretty much just pays for her gas. They don't give them the hours.
Right. Any other, have we looked at all other options available to try to increase the payments? And is this where we are? Are we at a standpoint?
I think at one point you even got her financial records in the past and looked at that and reviewed it. And that's,
Well, I know.
yeah,
I know.
so this is what she can pay
I
right
know
now.
it was just frustrating, but
It is what it
Yeah,
is.
but
She can only pay.
that's a lot of money that was stolen. And then now we're shrugging and kind of shuffling around about, well, I don't like it. It's not right. It's not fair. I'm not sure what I can do about it. How often are we saying, are we reviewing it? Every 3 or 4 months?
It's been every 6 months.
6
now.
months.
Get a reset. Evan Johnson. Here's this file.
I haven't seen it made a condition here.
I believe the status is in this probation. Mr. Johnson
Really?
is doing everything she's supposed to be doing. Things on the tablet. She is still on probation. She comes.
Wait.
Yeah.
They dismissed the motion?
Yes, we are.
She pleaded true to theft
I've
while on probation for a crime.
conferred with the probation department. They're in agreement with the dismissal.
And then just let her continue on probation.
What happened to the underlying theft case?
And not
I don't know, sir.
Well, I mean, shouldn't we know? I mean, she committed a crime while on probation. I never just dropped that. Why are we just dropping it? I know there's something I don't know, but she pleaded true to it and pleading true to drugs, drug screen.
I think probation has something off on it, Judge.
Why are we just letting her commit crimes? That's 2 crimes, theft and drugs. And then we're rewarding her?
I think there was an amendment, right?
There was an amendment, I think in October before I came on to send her to ISF, the zero tolerance. And she finished the ISF and she's been testing negative on her drug screens. And since then she's become employed. And her last drug screening was August the 5th.
Okay. So we're just going to dismiss the motion. She's still on probation.
Yes,
sure. She's
What
on
about-
probation.
What about the completed defensive driving program?
That was, we didn't put that in there because the
Oh, it's in
orders
the motion.
said, a theft class, but it was for evading. So we had to file another order to dismiss the theft class for the evading and then add the defensive driving for the evading.
So where are we on that?
So that one, we're getting to where she's gonna take it.
Well, it's about a year since we ordered it, right?
Yes, sir. It
Are
was.
you squeezing this into your busy schedule?
Yes,
I
sir.
don't mean to be a smart aleck, but you committed a crime. We gave you a break. And then there's some more crimes being committed and foul ups. And then we're cutting you some slack. Why is that? I don't know. That doesn't seem fair to other people on probation. I got 5,000 people on probation. They're going to be treated fair. They're going to say, well, I'd like the breaks that Evan Johnson is getting, please. And how do I say no? I mean, what's fair is fair. For one, you open the door for everybody, right?
Completely understood, Judge. The thinking was there has been a sanction. There has been a price paid for this opinion. And after consulting with probation, the states have the opinion to leave her on probation. If she screws up again, this will also could be part of the next motion to revoke.
And how could that scare anybody when we handled this by just dropping everything? What are we really doing here? If we're not acting on what we say, we file a motion and then it's dismissed, and then our plan is, well, we'll just file another motion next time.
But the probation sanctioned her, Judge.
Yeah, but you know, at the end of the day, it's my choice.
Yes, sir.
So this court's probation, and you don't commit crimes, and it's two crimes after you were placed on probation. On the theft of property, what was that? It's like, it's less than $750, but what was, did she pay that back?
I don't know, sir.
Well, she pleaded true to, did you pay that money back or whatever it was on that? Hold on, everybody. She pleaded true. What did on November 25 to that? Well, there had to be a sanction, right? And what was the sanction then?
She did get, Your Honor, for that 46 days in the county jail.
Okay.
I'm looking that up.
Let's see, was there a loss involved on that?
I don't see restitution ordered on the theft case.
Let's see, what is it?
Did you have to speak record just to check?
Let's see, August 24th.
Right.
August 24th. Let's see. Evan Johnson entered a vehicle, a Ford Fusion, and fled from the parking lot. He stopped at a signal line. Traffic stop was conducted. Due to a strong odor of marijuana emitting from the cab, a probable cause search was conducted. While conducting the search, stolen items matching the description from target loss prevention manager were located in the back seat of the vehicle. On my watch.
So the items were recovered, Your Honor. I think it's what it was. I'm looking at the.
Not because of her.
Well, but they were recovered.
And Judge, we're
Both
happy.
individuals were observed. There are two people, Evan and another person, were observed concealing merchandise in their clothes, walked past all points, and the total value of the items were found to be right at $180. And it looks like the items were all recovered and returned. So there's not a loss to the store that got it back, but
We're happy to proceed to a hearing, Judge, if that's what the court.
Your Honor, I mean, back in November when she pled true to this, you sentenced her ISF that, like, I'm gonna agree with the state. And this is 2 days in a row. I agree with Mr. Coleman, which is getting scary, but we are agreeing here that she's been sanctioned. You sanctioned her by sending her ISF. She did that. And now she's on ISF, and the state doesn't want to keep this open any longer in the sense that she's on the right path now. And if she screws up again, then.
But you forgot, I'm the one that ordered the motion.
Sure.
And at the end of the day, and there are still 2 items that she didn't plead to: failing to perform community service hours and failing to enter and successfully complete defensive driving. Sorry, those haven't been dealt with. How are they going to be dealt with?
Well, we're happy to proceed with the hearing if that's the course.
I just wanted to do these things.
Yeah.
Successfully.
And since she hasn't pled true to him,
what are we going to
she
do
doesn't
on
do
the
that.
defensive? She was ordered to do that. Where is that on that? Have we done that yet?
I'm in the process of doing it now.
Sir, the ma'am?
I'm in the process of doing it now.
What, you're in the what?
Process of doing
it now.
Well, so what is it, the process? Where are you on? Well, tell me what the process.
Again,
How long have you had the paperwork?
I just got the paper since I was these are my probation officer.
When did you get paperwork for this?
Whenever she came in July.
In July?
Yes.
Okay, last month.
Because the original order had theft class on an evading charge, and we had to send another order to change it to defensive driving, and that happened in March.
Okay. All right. So she still needs to do that.
Yes, sir.
When is that going to be done?
I'll be done this night.
Yeah.
Huh?
30
It can be
days.
done as much.
Okay, that's ordered. You gotta do that. You gotta begin that within 30 days. And you don't understand, you're getting benefited from it. You take that and your insurance will drop. The insurance costs will drop. I mean, it's in your best interest anyway. Get that accomplished as soon as possible. Okay. And what else?
Well, I think the state's requesting to dismiss the motion to revoke, and then put her back on just regular leave her on probation.
We're gonna dismiss it after she finishes the defensive drive. We'll just hold it and just dismiss it once she completes it successfully, okay?
That works.
All right, you
Thanks,
get
Judge.
hardest for doing the right thing.
Yes, sir.
Thank you. All right, Michael Johnson.
Mr. Johnson.
And how are we doing on with probation?
He's doing well. The only thing he hasn't done yet is the more recognition therapy because we are waiting to get a later date for people who work past 5 o'clock so they can attend the evening classes.
Where are you working?
Giglio distribution.
I'm sorry, I can't.
Giglio.
Yeah, what do you do there?
Bill Sanders,
How much are you making an hour?
like 15.
Sir, about 15?
15.
Oh, yeah, that's over 30,000. That's cool. Good start. Good start. So from probation,
Yeah, he's doing really well. He's making payments. So far he's made.
fix this. You can do it.
Yeah.
I believe you're far better than what happened here. So do it. Yeah.
Yes.
Yeah. Make your family proud and you and move on successfully from this. You were placed on probation a couple of years ago. So what else? Anything we need to deal with or tinker with? No?
I'd like to submit a dismissal on the motion to revoke probation, Judge.
It'll be dismissed.
Thank you, Judge.
You ever ordered by doing what?
Yep. Good too.
Thanks, Mike. Rachel Langham.
Good day.
Threw that out there.
If you don't want it, you can send it on to me.
You don't need it now.
Hey, you know, let me just say, it's a rare event for me. So, but I tell you, I almost forgot because it had been so long that, and then, she went, what is this? And there it is in the mail. I said, my God, it really happened. Whatever.
August.
Anyway,
Let's say July.
okay, 26 CR 603. It's Rachel Langham. You're charged with this 3rd-degree felony. We're here on an announcement. Where are we?
She has attempted to and working on hiring Mr. Kindler. She's been trying to get with him. She has an appointment Friday to sit down with him to sign the contract and to retain him. I'm a court appointed attorney. I'm happy to stay on until that happens, but I would just ask for a little time for her to take care of that, a couple of weeks for Mr. Kindler to get on and then let him do what he needs to do with it.
Okay, it was indicted in April. Oh, what a small world, April 15th. So we know that's been 4 months.
We know how long that is.
Since we tabulated it up.
Yeah. So it's not an old case. It's,
well, but I'm sure that
I would hate to start doing.
I'm sure the victim doesn't find it amusing. That's why, and that we're talking about an elderly person is a victim here. And what is it? The
credit card.
Is it $320? Is that it?
I have to discover.
Yes, sir.
Yeah, it should work out. Coming out then.
All right, I'll reset forward.
Get back. Reset and
On this line.
stick around. I'll talk to you in detail.
Let me know about how that works.
Yeah, we're gonna try to get that.
And Derek Laverne.
All right.
Oh, there's the motion. Hello.
Who's
With the money thing, that's why it's been sitting around.
Yes, sir.
Who's this?
Mr. Laverne.
Derek Laverne.
Judge, his probation has expired for a long time and it's not restitution, it's fees and stuff. So I file a motion to dismiss.
Oh, okay. Well, you object to that?
Nope.
All right.
Okay with that.
Then wise move.
No.
What are you on defer? Is he on defer?
Yes, sir.
Go and sin no more.
Yes, ma'am. Will do.
I was tired of dealing with it anyway.
Well, you did it.
You do what you're supposed to do.
You made a mistake. Welcome. The whole planet makes the mistake. And we all do numerous times. It's how you fix it. That's the test. You did well. Thank you. Good work.
Hopefully I'll see you for this.
Luis Valencia. Luis Valencia in cause number 26 CR 669. There is no answer. I asked the bailiff to call into the hall.
Huh?
For Luis Valencia. Luis Valencia in the hall.
I remember.
Okay, so you're not.
Yeah, he's not gonna be
Anybody
here.
at all?
Okay.
Not here.
Yeah, he got it.
Anybody call out the hall at all?
I think the government gave him a ride back home.
Did you yell louder? He's across the border.
Oh, is
He got deported. Yeah.
Yeah, so it's,
He did a cash bond, so there's a slight.
so he's.
Okay, fine. Okay, well, we can vote for that. Well, then I'll dismiss. What do you mean no?
You were supposed to be looking at
No
the
response, John.
person who wrote the.
Oh, the lady,
All right, there is no answer. We called the name here in the courtroom and in the hall. Defendant has failed to appear. He's charged with a third-degree felony of evading arrest.
yeah, there's no priors and he's been deported.
It says, hello, my name is Kimberly Lazaro. I am the person who paid Luis Valencia's cash bond. As you may know, he got deported and we never got our cash back.
Okay.
Okay.
All right. I'll dismiss it, Judge. We'll just get rid of it. He doesn't have any priors in it. It wasn't that bad of an evading, so.
All right, that is going to be dismissed by the state.
Yeah.
And James Frizzell. Frizzell.
Thank you for reminding me of it.
You are.
I forgot.
I meant to email you yesterday and provide you.
That's the one that's trying to get phone back.
Yeah.
And today, what are we going to do today?
We're gonna please.
Oh, all right.
Yes, sir.
Come here with collecting.
No, she did. Well, I don't know if she can get through.
And we now call 25 CR 1495, the state of Texas versus James David Frizzell. That's you, sir?
Yes, sir.
Correct. And you were here with your attorney and the state's attorney. Mr. Kelly, does the defendant waive formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, we do, and we can, please, Judge.
In summary, sir, this indictment alleges that on or about December 12th, 2024 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. DWI, driving intoxicated, as it's referred to. Paragraph 2 goes on to allege, though, that you have 2 or more prior convictions of DWIs. One on January 25th, 2007, out of McLennan County Court at Law. And that was in 2007. Also, that's weird. Later that year, you had picked up another DWI, or operating a motor vehicle while intoxicated, out of Collin County, Texas. Because you have 2 or more prior DWI convictions, every time you commit another DWI or operating a motor vehicle while intoxicated in a public place, it's a felony offense in Texas. So you were looking at a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. This is a 3rd-degree felony. Do you understand? Yes. Respond, Jimmy. You can do it. Yes.
I'm sorry.
You understand?
Yes, sir. I interrupted.
Okay, good. Hold on. Let me work with the stylus. What are we doing on that? We get another one, or we're just going to be driven crazy with this thing? This one.
Just for a little bit longer.
Sure. But you don't have to be sequenced on DWS. Oh, no, prior to DWS. You don't have to be
Different
sequenced.
issue.
Yeah.
An agreement's been reached where you would be pleading guilty, found guilty. After being found guilty, you would be sentenced for what?
The agreement is for a 7-year probation, 10 years probated for 7 years. Judge. That's the.
Oh, okay.
We negotiated. I will say this, Judge, we put 10 days as a condition in there.
So I've
We
got
neglected to
confinement in the institutional division of the Texas Department of Criminal Justice for how many? That didn't get filled in. How much time?
Confinement for 10 years. Your Honor,
And that would be suspended,
for 7 years.
and then you would be placed on regular probation for 7 years.
That's right.
And fined $1,500. There would be terms and conditions of probation, though, that are normal and customary for DWI cases, which are special for alcohol and sobriety and operating motor vehicle responsibly kinds of conditions. Also, as a condition of a DWI 3rd, you must serve at least 10 days in the county jail as a condition of probation.
Your Honor, speaking of the conditions, I'm sorry to interrupt the court.
Yeah.
We neglected to write ignition interlock in their plea paperwork. That was part of the deal.
I think
That's probably standard. It's probably standard.
that's always standard.
I just feel better about putting it in there, but it's
That's
just. if it's
and
standard.
it's statutory.
You can't not agree to it. It's a condition of probation.
Okay. I just like to put it in there. Thank you, Judge.
Okay. Do you feel better?
I do feel better without.
Oh,
I put it in there, Judge.
I feel better.
We all. It was just looking over there. I see just a sense of relief
It is.
after he said
It
that.
really
Just-
is.
I'll feel better this afternoon too, Judge.
That's telling your sins to the priest. You feel better at the end of that. Some people. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
So how do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, those prior DWI convictions, are those all true as they are alleged?
Yes, sir.
And are you pleading true to paragraph 2, those 2 prior DWI convictions, voluntarily, knowingly, intelligently, and because those are all true and correct as they are alleged?
Yes, sir.
All right. I'm going to show you, sir, what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered in
Objection states-
without objection. It's submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, please, Judge.
I just want to ask you, James, this is the third one. What do you do? What are you doing to change what's going on here? I know you've thought about it, and now you're looking at going to jail, and it's a felony, and it's a felony for the rest of your life, you know?
Yes, sir.
So what are the next one would be a second degree felony punishment, up to 20 years in prison.
Yes, sir.
Well, what are you doing to fix all of this? It's really, most of this is in your court.
Right.
What are you doing individually to make sure that this won't happen again?
I mean, obviously I've got to do something about my drinking.
Well,
And I've been
like
working
what?
on that, you know.
Well, they're going to help you, but
Yeah,
still,
absolutely.
at the end of the day, we're not at your house watching you with a video. I got you. You don't drink. It's going to be your choice.
Right.
What are you going to do about that?
Just not drink. I mean,
Okay, is that simple?
is it-
I mean, can you make that decision? I mean, you're not, or is there some alcoholism or anything that prevents you from making the choice to do the right thing?
no, sir.
Okay. Oh, well, then fix this.
Right.
Okay. You got a lot to lose here. If family is at home, do you have a family at home?
I don't have a family. I mean, I've got mom, dad, brother,
Okay.
sister.
Well, okay. Well, but at the end of the day, you got you
Right.
too. And you don't want to flirt with more trouble here.
Absolutely.
Because this is, you touch the stove, it burns. Don't embrace the stove. All right. If nothing further, here's what I'm going to find. That you are pleading guilty voluntarily to paragraph 1 and true to paragraph 2, which constitute a third-degree felony of operating a motor vehicle in a public place while intoxicated, a third-degree felony. You are mentally competent to do so. You to make these pleas of guilty and true. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, as you are giving up your rights to a jury trial and the rights to the appearance, confrontation of witnesses. I now find you guilty beyond a reasonable doubt of this third-degree felony of operating a motor vehicle in a public place while intoxicated with 2 or more prior DWI convictions. I am following this agreement. You're hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement will be suspended. You were placed on regular probation for 7 years. As a term and condition of probation, you must serve 10 days in the county jail. As a mandatory condition, you must pay a fine of $1,500. There will be other terms and conditions of probation. There are 36 of them, although most of these are conditions your attorney, me, all of us here have to follow. Don't commit crimes. Avoid bad habits. Don't associate with disreputable. Those are all good ideas for all of us. But we don't have a lot to lose like you do. If you fail, your probation can be revoked and you can be sentenced and go to 10 years in prison. And for DWIs, they kind of keep people in longer than normal. So you don't want that. All right. Also,
Page 4. Where's
the one for? Okay.
Yes, sir.
The additional, have an auto ignition interlock system installed in your vehicle and complete the Texas DWI repeat offender program and pay associated costs. And those associated costs sting, but in the long run, it'll cost less by taking that and completing it than it would otherwise. You would have to, your insurance would go up a sky high and other costs would be applied. And if nothing else, that's a deterrent to keep you from backsliding on this because it's, these DWIs cost.
Absolutely.
They sting.
Yeah, I do. And ready to go.
All right, and all of these are to help you complete the program successfully. We want you to get back on your feet and work. You got a job, I
Yes, sir.
presume. Well, is it a responsible job?
I believe.
Yeah, you got people under you?
No, I don't have anybody.
But I mean, but
I-
okay, the
yes.
people who employ you, do they rely on you?
Absolutely.
So, then don't let them down. Don't let yourself down. You're better than this and you can do it.
Yes.
Okay. 10 days in the county jail. When do you begin that? Well, how do you want to do that? Do you work during the week?
So I work a week on, week off. I work on a tugboat.
Judge, may we do them from August 28th to September 1st and from September the 10th to September the 15th?
Did you do your math, Tom? Did that come out to 10 days?
It's like 10.1 days.
Right. I think you've got a weekend and then 2 weeks later,
I think
right?
it's 4 and 6.
4 and 6. Yeah, get the calculator, see if that comes up to 10.
For the first group and then 6 the second group.
Take about Mr. Coleman's.
High school, in high school, interscholastic, first place in number sense. I won first place in number sense. So, yeah, it's 10 days. Okay, I'm gonna allow you to do that. It's awkward, but we work with you on this. We just want you to get it done quickly, move on with your life. Because nothing's happening. You're just vegetating in the jail and, get this behind you and move on and do great things. Your tugboat?
Yes, sir.
Okay. When I was in private practice, we represented some folks, shipping folks, and they all did well, but it's a very responsible job.
Yes.
There's not only value of cargo and the vessel, but other people's lives that depend upon it. So we know you made a mistake. Don't do that again. A lot of lives depend upon you operating that multi-ton tug responsibly.
Yes.
Plus driving a 4,000-pound car. Okay. And do it.
Yes, sir.
And do well. Get this behind you and move on and be the very best you can be. Anything else?
Not from much.
Okay, Tom. Thank you very much.
Thank
That
you.
is all.
I'm gonna do a memo to the jail with the exact dates. I'm gonna send it to the office. Okay, so he can have it with him. That way, if you're confused, it was just confusion.
Okay.
Because it's like a Friday to a Tuesday.
Yeah.
Yeah. Sometimes they don't find stuff when you send them, but if I give it to them. But I am gonna send it out.
I got 24 CR 1671, Evan Johnson. Motion to dismiss.
No, that's the one you didn't want to do.
What I didn't want to do. So I'm gonna pass on that one.
Yeah.
Well, so what are you
Michael
gonna,
Johnson was okay.
so what are we gonna do with, when do we bring Evan back?
So
Is taking a defensive driving.
Okay, but we got that in the queue, right? We're gonna get that done in a month.
Yes, I don't know how long it takes.
All the small stuff that she usually classes a month. Yeah.
Okay. He wants to know. They could just,
All right, Michael Johnson, 23CR 1765. That motion to dismiss has been filed and signed. Derek Lemur. Motion to revoke probation. To be dismissed.
Go look and see he's passed out behind the wheel.
He's got a prior.
He wasn't in a parking lot. He hit him with the road, okay? He was in the middle of the road. He's up with the train.
And Luis Valencia, 26CR 669. There's a motion to dismiss before the court. Times.
You have the probation budget thing today.
Yeah, what time is that? 11, isn't it?
I think it's noon and it is next October. I think in their, it's
All right. Anything else? We're in recess. Have a great.
I'm not in charge of coming out.
Wow. That was. It's not how you would. That's, I don't know, Your Honor. I'm sure, yeah, she would give it real, I don't know what that's about.
No.
It's okay. I'm not hurt, but wow. Court calls the case, People versus Leslie Bryan.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brown. Mr. Brown, state your name for the record, please.
Brown. Thank you.
So this is a show cause for money owed on an old case. Seeing as Mr. Brown is in custody, I'd ask for an adjournment.
You're brilliant. No, come there.
Sorry, I didn't hear you.
I said, when you said he's in custody, I said, oh, you're brilliant. No, I'm coming after the account. How much does he?
I had 440.
How long have you been in?
About 40 days.
Is there some of it? What do you have?
I'm here. I have a year sentence here. I've told you that. Well, I told my lawyer I had a year sentence here, so I'm gonna be here until April. I didn't procure the money when the last time I came. He told me to come and pay. I think like 100 or something. I didn't procure the funds before I came, so I didn't know I was not going to be able to pay the rest of it.
We're gonna waive all the fines and costs except the statutory fees. You're all set. Good luck to you and me. Court calls the case, People versus Michael Naparella.
Good morning, this is on behalf of Mr. Naparella, who is in custody in the Ohio Department of Correction.
Your Honor, I can confirm that he is in custody in Ohio. Given that he's not present, I would ask the court to adjourn this out to September 23rd with a writ being done to the Ohio facility.
I'll adjourn this out to, you want the late September date or the October date?
The late September date, I think would be sufficient.
September 23rd, 2026. Is that at noon or 9 a.m.? There was only one on, correct? Court calls case People versus Jason Haas.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Haas. State your name for the record, please, sir.
Jason Haas.
We did review the sentence recommendation in this case. We ask that you adopt it.
Sir, anything you want to tell the court before I impose sentence?
Just that I'm realized the wrong and working on myself. I'm gonna do better from now on.
Court acknowledges that this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I will place you on probation for a period of 24 months. You are to pay $1,255 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When do you think you can get that paid, sir?
Well, after this, I'm gonna go to another county. They want to give me a year.
Pardon?
I'm gonna go to Livingston County after this, and they want to give me a year cap for a UDAA. So I don't know how it's gonna work, sir.
Okay. Here's what I'll do. I'll just indicate that it's to be paid by December 31st, 2026, and then we'll figure out where you are at that point.
Yes, sir.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll report to community corrections within 24 hours to begin weekly random testing. I'll do it this way. If he's going to Livingston, you have to report to community corrections within 24 hours of release.
From Livingston?
Right.
Yes, sir.
You're to complete outpatient substance abuse treatment, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with verification to probation. Provide proof of victims impact panel attendance to probation. On order 365 days in jail. Credit 27. The balance on this case is suspended.
Thank you, Your Honor.
Thank you.
Oh, man, let's use it.
I'll watch the thing.
Court calls case People versus Kimberly Bronson.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Bronson, who's in custody at the Wayne County Jail.
And Teresa Blair on behalf of probation and Your Honor. I did confirm that Ms. Bronson, she left our facility and was transferred over to Wayne. So she is there. Probation's asking for an adjournment for writ in that case. Not opposed to September 20th or the 1st October date.
What I'll do is I'll then adjourn this matter to September 23rd, 2026, 9 a.m. What are you doing, Buckovich?
Wait for my case to be called.
No, I was asking, we missed you when we started. And we asked Miss Perrine where you were. And oh my God, her response. I'll let her tell you. She should tell on herself. It was very non-Perrine. Court calls the case, People versus Theory Reynolds.
Good. Assistant Public Defender Lauren Kearney on behalf of Mr. Reynolds, who is approaching. State your name for the record when you get to the podium, please, sir.
Theory Reynolds. Good morning, Your Honor.
Good morning, sir.
Your Honor, Mr. Reynolds is also in custody. This is a show cause for money owed. I guess for an adjournment of the show cause.
It's the
How long have you been?
110. How long, what are you in for?
Can I say something, man?
Stop you, I guess. Go ahead.
So I was in here last year from August until November.
You were in custody, you mean?
Yeah, from August to November, I got released, but I had seen you for this apparently, and I was wondering, like, at some point, would I be able to like move for like time served or something? I don't know how much this charge carry or what, but I really don't have no money.
Okay, I know. So how long are you in for right now? What are you in for?
I got a couple charges I'm in for right now. I go to court tomorrow. Actually, I'll see you tomorrow. I'll see you tomorrow.
For me?
Yeah.
What's charged?
Felony.
Well, I know that, but
When did you come to custody?
oh, small stuff.
Because of this month
Yeah.
of August?
Are you under sentence on any case?
No, sir.
So you have that case that's with me tomorrow.
Mm-hmm.
Then that's it? That's all you have right now?
Yes, sir.
You still have it up. What's his bond?
My bond on the case tomorrow, Your Honor, excuse me.
Yeah.
$1 million.
It's $1 million?
Yes, sir.
In this case is driving while unlicensed, which apparently people do. Way to be so no.
It was out loud, somebody.
No, I don't even want to know. Just here's what I'm going to do. I'm going to waive all the fines and costs except the statutory fees. And that way you're done with this.
Your Honor, excuse me. Thank you first for foremost.
You're welcome.
What the statutory fee is?
I think it's going to be 125. It's going to be 125, but counsel could explain to you about that.
Okay.
Okay. Just
Read back.
All right. Thank you, Your Honor. I appreciate.
You're welcome.
Sorry for speaking too much.
What?
Sorry for speaking too much.
No, you're good. Just don't do that tomorrow.
Oh,
All right. Take care. All right. Court calls the case. People versus Devontae Johnson. 2 cases.
Assistant Public Defender Nicholas Buckingham on behalf of Mr. Johnson.
Welcome back.
Thank you.
All right.
Claire on behalf of probation, Your Honor, Mr. Johnson, I have confirmed is in the Gallatin County Jail. So therefore I'm asking for an adjournment with a writ to be issued, and September 23rd would be fine with that as well.
I'll adjourn. These are 2 matters, correct?
Yeah.
September 23rd, 2026, 9 a.m. Court calls case. People versus Trayvon G.
Good morning. This is the Public Defender Lauren Perry on behalf of G.
Sir, state your name.
Trayvon G.
Thank you.
Teresa Claire on behalf of probation, Your Honor, Mr. G is before the court for review hearing on a prosecutor deferred sentence. Mr. G has completed all terms excepting he has a balance of the $435. Given that he is compliant in all other matters, probation is recommending that the court give an extension of the prosecutor deferred sentence for a period of 3 months, that Mr. G make a payment of $145 beginning on September 1st, 2026, and then $145 per month thereafter, that he continue with all other terms as previously ordered, with the review hearing being set November 16th, 2026 at 9 a.m.
I have no objection. I wasn't able to speak with Mr. G, so I'm not here have any objection, but I think it's a reasonable recommendation.
Okay. Mr. G, you heard
Yes.
all that?
Yes, I did.
You think you can do that?
Yes, sir.
Okay, so you'll be able to pay 145 each month beginning the 1st of September?
Yes, I will.
Okay, let's try to get you through this. So I will extend the prosecutor's deferred sentence for a period of 3 months. He's to pay $145 per month beginning September 1st, 2026. Continue all other previous terms as ordered. I'll set a next review hearing for November 16th, 2026, 9 a.m. All right.
Okay.
Thank you, sir.
All right. Thank you. Have a great day.
Court calls case People versus Tyler Meddy.
Good morning, Assistant Public Defender Laura appearing on behalf of Mr. Meddy. Mr. Meddy will not be present. I did speak with him this morning that he was on his way to work. He had to be at work at 9:30. While at be on his phone, so he can't come on. He did want me to request an adjournment. He said he just got this new job. Worked on I think it's Lombardi's Food, driving a forklift, so it's a good job. He really shouldn't afford to move at this point, so he was behind on his rent. He did say that he would be able to pay off the rent in about a week or two.
Will that pay everything?
No, there's other costs.
Got it.
About $400. He said he could make about a $500 payment in the next couple of weeks.
All right, so here's what I'll do. I'll order that he pay $500 by I'll just make it the end of this month by October 31st. August 31st, 2026. All right. Then did he indicate to you what he could pay per month or anything like that, or no?
He didn't, Your Honor, but he
Okay.
did say he back to work and it seems to be caught up on his bills.
Thanks. Okay. So then he's to pay that by that date. I'll adjourn this matter out to October 14th, 2026, 9 a.m. Okay. Court calls case People versus Angela Stoker.
Good morning, Assistant Public Defender Laura appearing on behalf of Ms. Stoker.
Hello.
Hello, Ms. Stoker.
Teresa Claire on behalf of probation. Your Honor, Ms. Stoker is before the court for a review hearing on a prosecuted deferred sentence. Ms. Stoker has completed the programming component. She still has the balance of $390. Was speaking with Ms. Stoker, she had changed jobs. So there were some financial issues. She is working and is steady now. Probation at this point is asking, given that she's compliant with reporting and the programming, that the court extend this prosecutor deferred sentence for 3 months to allow her to complete it successfully. Probation's also asking that she make a $90 payment on or before today. Ms. Stoker, did you make that payment?
I'm gonna do it today.
And then $100 per month thereafter, that all other conditions continue with the final review hearing being set November 16th, 2026 at 9 a.m.
I have no objections to that, Your Honor. Ms. Stoker indicated she could make the payment. Any objections to any of that, Ms. Stoker?
No.
All right. So you'll be able to make the $90 payment today, right?
Yeah.
Okay. So here's what I'll do. I'll extend your prosecuted deferred sentence for a period of 3 months. Pay the $90 today, and then you're going to pay $100 per month beginning in September. Continue all other terms as previously ordered. I'll set a next review hearing for November 16th, 2026, 9 a.m. All right. Thank you, Ms. Stoker.
Thanks.
Court calls case People versus Brandon. Here yet. Koza? Here you, Koza. Oh, boy. Here we go. I'll let everybody stop. All right, she was here. I didn't know she was even gonna get to talk today, but now she's gonna talk.
Hold on, there's that. Honor, Mr. Sewell, and Mr. Kirkoza is before the court for a review hearing on the prosecutor's jurisdiction. He completed all terms in the beginning. And completed the events. Probation.
Yeah. Buckervich. Did you know she's a USC Trojan?
No, I didn't know that.
Didn't know that? We don't like them, do we?
I'm neutral.
Okay. So ordered, Judge. Thank you. Wow. I'm getting no help over it. Court calls the case, People versus Nicholas Stemmel. Oh, she's up again.
Your Honor, Mr. Stephen is just before this work for review hearing on the prosecutor's sentence. He's completed all terms and the hearing has been.
So hold on and I will share my screen. Okay, hold on.
Didn't make the wrong decision because I don't know what.
Yes, all right, can you see your screen?
Yes.
Let me see if I can make it any larger for you. Okay, give me this in the Can you read that now?
Yeah.
All right, so there's 12 paragraphs. The other gentlemen that are in the jail, if you want to read that, if you're still there. Okay, thanks.
Over here, Route 2 forward, please. Well, open up seat this.
The attorney can go to room number 4.
Okay, have you finished it? Are you still reading?
Yeah, it's like, all right.
Your case. They haven't come in yet?
I'm next after this.
I'll read them out, we're playing just 4 things today. We're gonna do double lessons as well. So I can take them back and then find out.
And Mr. Prophet, are you finished yet or not? All right, did you have any questions about any of those rights that are listed there on the form? So you understand, if I do accept your guilty plea, you will not have a trial and you'll be giving up those rights that were listed there? You also understand the possible penalties on this charge that I told you earlier? 90 days up to $100 fine, not including cost.
It's like a new ordinance, it's for 26 this year.
You still, who?
So they'll explain more. I know that's somewhere.
Who has to plead guilty to that charge?
Yeah.
Do you still wish to plead guilty as charged?
I really don't know what's going on, so,
Sir, you want a lawyer? I can get you a lawyer to talk to you.
yeah.
Okay, we'll adjourn this and we'll have to get a lawyer. And I don't know how we're gonna get him to fill out the form because he's in custody. So I think, Jessica, you're gonna have to fill some stuff out for him. We'll need an adjourn date for counsel to be appointed. And when are you coming out on 30 days?
When do I leave?
He said he gets out August 27th.
Okay, so we're gonna put this after August 27th so you can come in person. Okay? Okay,
Court's available September 2nd at 9:30.
September 2nd at 9:30. You're gonna come to the 46th District Court in Southfield.
Okay.
And we're going to need to get some information to see if we can get counsel appointed for you.
I don't know, does she ask him if he can chat me?
Can you type into a chat?
Yeah.
You can? Okay, my assistant is going to chat with you and try to get some information so she could fill out the request for court appointed attorney. Okay? All right. So you're going to be all set and we're going to see you on September 2nd, 2026.
Oh, can you bring the parent? Ready on the next matter, Judge.
This is case number 26S00691FY, People of the State of Michigan versus Samuel Migliori.
Good morning, Your Honor, Laura Kamaj on behalf of the people.
Sir, can you hear me?
Yeah, I can hear you.
All right, tell us your name.
Samuel Migliori.
All right, Mr. Migliori, you're here for a probable cause conference. As of today, we don't have a lawyer for you, but I will tell you what your charges are. Huh? Go ahead, say what you need. You're here for one count of, let's see, receiving and concealing stolen property, which is a motor vehicle. And that is a felony charge carrying a maximum penalty of 5 years, $10,000 fine, or 3 times the value of the vehicle, whichever is greater. Then you have a misdemeanor operating while license suspended. It's a 93-day misdemeanor with up to $500 fine. And possible driver's license issues such as points, additional suspension of your license, possible vehicle immobilization as well. And you have a right to have a full preliminary examination within 21 days of your arraignment and within 7 days of your first appearance, which was back on July 29th. And it looks like you waived that time frame. So we don't, you were supposed to hire a lawyer, it says here, but you didn't do that yet. Is that correct, sir?
Yeah, I didn't do it yet.
So are you going to be hiring someone or you need a well, it's really not court appointed, but an assigned counsel?
I think I need a assigned counsel.
Okay, so what we need to do is adjourn your case. And what jail are you in? Oakland County Jail, okay? So we need an adjourned PCC date. He needs a lawyer.
Court's available August 26th at 9 a.m.
August the 26th at 9 a.m. It looks like you had some holes out of 36th District Court and the 16th Circuit Court. You still got holes for those matters in those courts?
No.
Okay. Well, if you get out, you need to be here August 26th at 9 a.m. We need to also fill out a form for him.
I'll pull the time back just in case he doesn't get out. He can be on video.
Okay. What time?
That's 10 a.m.
What?
10 a.m.
Okay, so we're gonna do 10 a.m. instead of August 26th at 9. It'll be 10 a.m. So if you'll hold on, my assistant will chat with you. Can you answer in the chat too?
Yes, I can.
She'll get the information that she needs to fill out the form for you. And then we'll
All right.
see you back on August 26th. So you're all set.
Ready on the next one.
This is case number 260S19229A. SI, People of the State of Michigan versus Fadi Mirza.
Ready, Your Honor.
People.
Okay. And Mr. Mirza has an A and a B case. Mr. Abuzay, where are you?
Hi, Judge. For the record, Ziad Nicholas Abuzaid. I do have authority to plead responsible to an impeding traffic and dismiss the other 2 charges.
All right, is that the offer?
Your Honor, I do have just 2 civil infractions here, one for no proof of insurance, the other one for speeding 105 over.
Yes.
Speaking with the attorney, he indicated to me that his client does now have insurance. And based upon that information provided by the attorney, I am willing to dismiss the no proof of insurance as well as reduce speeding 105 to impeding traffic.
Okie dokie. So, and he's already indicated that he has authority to accept that offer. So as to the added count of impeding traffic. All right, the court notes that matter occurred. This would have been on July 9th, 2026, 2:52 p.m. Respondent was operating a Chevrolet Silverado vehicle on Evergreen Road near Saratoga Street, which are highways open to vehicles in the city of Southfield. So with counsel's authority, I'm going to accept this plea of responsible to this added count of impeding traffic. And we're going to dismiss the original count here, 1 to 5 over the limit, as well as count number B, which is the no proof of insurance. All right, and so the impeding traffic has a $160 fine. I believe it's $160. So do you need time for that?
2 weeks would be great, Your Honor.
How much?
2 weeks.
Okay. So today's August the 12th, so that's August 26th, okay?
Thank you, Judge Johnson. Thank you, Laura. Have a beautiful day, everyone.
All righty. See you next time.
Bye-bye.
Ready on the next.
Case number M4716854 ASI, State of Michigan versus Emilian Komar.
Floor question, people, Your Honor.
Told you to start sending it for the attorney of record, Mr. Fowler. We've come to a resolution here whereby the original dues to impeding traffic. I do have the authority to accept that off on my own.
That is correct, Your Honor. That is the people's offer.
All right, and so the court would note that original charge is failure to stop and assure clear distance ahead. And that this matter occurred July 13th, 2026, 5:30 p.m. Respondent, Mr. Komar, operated a Volvo motor vehicle. This would have been on northbound M10 Lodge Freeway near Telegraph Road, which are highways open to vehicle city of Southfield. So with council's authority, we accept this plea to the added count of impeding traffic and will dismiss to failure to stop the sure clear distance ahead. Standard fine again, 160, and you need time. Let's say August 26th. All right, you're all set.
Thank you.
Next, Lonzo Miller,
Ready?
case number M472749B. And wait a minute. Oh, there's an A2 as well. And these are both people, state of Michigan versus Lonzo Miller. Okay.
Take the floor across the people.
All right, sir, what is your name? Mr. I'm doing pretty good, Mr. Mead. All right, so you're here for two matters. Apparently, the A matter is an improper right turn. That's a civil infraction. And the B matter is failing to disclose a concealed pistol to a law enforcement officer. And so, of course, you have a right to have full hearings on all of these matters, but you may have already spoken to the prosecutor and worked something out.
Yes, Judge.
Okay.
The people did extend an offer. The people would move to dismiss the CCW failure to disclose if the defendant were to plead responsible to the improper right turn. He indicated to me that he wants to accept that offer. Is that correct, sir?
That's correct.
All right, sir, let's take a look here. So as to the improper right turn, this matter occurred July 8th, 2026, around 2:05 p.m. when you were operating a Ford motor vehicle on West 9 Mile Road near Southfield Road, which are highways open to vehicles, city of Southfield. And you want to plead responsible to making, and let's see, what did you do? You turned right onto 9 Mile Road and then turned straight to the left lane. The right lane was open and clear. So that was an improper turn, apparently, improper right turn. You want to plead responsible to that? All right, I'm going to accept your plea of responsible. And dismissing the other count of failing to disclose. Now, you do know what you got a CCW, right?
Yes, ma'am, I do.
Okay, so you gotta know, you gotta say it as soon as the police come up. Don't even wait for them to say anything to you. You say, hey, my name is so-and-so and I have a concealed pistol permit and I have a weapon on me. Just tell them that. That way you avoid this. Okay, all right. Let's see, the improper right turn. Let me see what the fine is on that. Okay, improper turn. It's on the other side. Usage. Here it is, improper turn. So that is a 2-point violation and $140. So did you have the 140 today?
Can I bring it Friday? I'm have to pay from bodyguard.
Okay, what you talking about this Friday?
Yes, ma'am.
Okay, so we're talking day after tomorrow on the 14th. All right, what time can you get here? Because they close at 4:30. Yeah, you're fine. Okay, so August the 14th is fine. Okay, court officer is going to take you down. So we got one dismissed and one that they're going to probably give you a notice to pay by the 14th. Okay, so you're all set. Next.
I get one off. Looking for Hannah.
Who? Is this next?
Yep.
Okay. Case number 26S00731FY, people of the state of Michigan versus Destiny, DESTINEE, Mobley.
Yeah, we go.
Good morning, Your Honor. State for hearing with, on behalf of and with Ms. Leslie Mobley, stand for my left, Ms. Mobley, can you say your name for the record, please?
All right, and good morning, Ms. Mobley, Mr. Frey. All right, so ma'am, you are here with counsel. This is for, looks like a probable cause conference, and this is our first appearance on this. And so the charges here are, looks like I got, okay, one count of felonious assault or assault with a dangerous weapon. That's 4-year felony, $2,000 fine. And then we have count 2 is a misdemeanor domestic violence carrying 93 days, $500 fine. Then we have a count 3 misdemeanor assault or assault and battery carrying 93 days, $500 fine as well. And a count 4 disturbing the peace carrying 90 days and up to a $500 fine. So you have a right to have a preliminary examination on that felony charge only. The misdemeanors are kind of just trailing along with the felony for disposition, but you have that right for the full preliminary hearing on the felonious assault within 21 days of your arraignment date and within 7 days of today's first probable cause conference date. So if everything falls into place, that's a pretty quick turnaround that you have for your hearing. So you understand that? Is that a yes? Okay, thank you. You have to speak. Because I see you nodding, but we have no way of transcribing the nod. Okay, so Mr. Frey, do you have your discovery?
Your Honor, I have written discovery, I've reviewed it, and I do not have video discovery. The incident itself, almost the entirety of it is allegedly on video. I've spoken with the assistant prosecutor. She doesn't have it in their system yet, either. So I do think we need an adjournment to get that video from the Southfield Police in order for me to properly advise Ms. Mobley about whether we should hold an exam, waive an exam, or seek a different conclusion. I am asking for an adjournment for that purpose. I apologize. I did not speak with Ms. Mobley about the 21-day waiver, so if I could do that on record, explain it to her.
Sure.
Okay. Ms. Mobley, a minute ago, the judge explained you have a right to have the preliminary exam within a certain time period after your arraignment, within 21 days. Because of what we've spoken about, I think it's in your best interest to waive the right to have it within that time frame. We're not going to give up the right to have the preliminary exam if we choose, but we're giving up the right to have it immediately so that we can get the video. Is that something you're okay with? That's my advice, but you don't have to do that. Okay. All right.
Okay.
So, Your Honor, we're willing to waive the 21 days if the court would oblige us with an adjournment so we can get the video.
All right, ma'am. So you understand what's going on. You're not waiving any major rights. You're just waiving the right to have the exam within a certain time frame because he needs to have everything to prepare the case and he doesn't have it yet. So you're willing to waive that right. Is that correct? Okay. So we'll find that annoying voluntary waiver for some discovery. And well, let's see. People don't have it yet. Do you have any idea how long?
I did just check again, Your Honor. I do now see it. I don't know if I didn't see it the first time or if it's literally just came through.
Okay.
But
So not bad. He can just get it right away, pretty much in the next day. Okay. All right, Madam Clerk, what you got? Fairly quick.
Oh, quick?
Yeah, because he's gonna get it like within the next day.
Court's available August 20th at 1:30.
Your Honor, I am going to be in Clarkson as the arraignment attorney that
Okay.
Court's available August 31st at 9:30.
that's fine.
Okay. 8:31, 9:30. Her bond is continued. That is for another probable cause conference. And hopefully we should have the video. Somebody gave me this appearance. So I'm not sure if they need an appearance for you or if that was for somebody else. Let's see.
Your Honor, I think this is the case that I had sent my experience to your clerk. I didn't remember if I could send it to her directly or to one of the criminal clerks.
Probably the criminal court downstairs.
It's an advance report, but I can make sure if there's not one in the file, I can.
Yeah, okay, we'll give you the green sheet here. And you can fill it out. Let's put the case number on it. 26S 073. Okay.
Sorry, on the 31st, what time? 9:30?
Okay. We're all set on this one then, ma'am. You'll have a notice to sign and then you'll be all set, okay? Ready on the next case? Case number 26S00732FY, People State of Michigan versus Gavin Ramsey.
On behalf of the people.
Okay, Mr.
Please is on court, Richard Taylor, we have Mr. Gavin Ramsey, who was present.
All right.
But Mr. Ramsey, can you put your name on the record? Yeah, Ramsey.
All right, and good morning, Mr. Ramsey, Mr. Taylor. You're both here today for a probable cause conference on a felony charge of, let's see. We've got a count 1, fleeing and eluding the police, 4th degree, maximum penalty 2 years, maximum fine $2,000 fine, possible suspension of your driver's license by Secretary of State. And that's the count that we're here for. And you, of course, have a right to have your preliminary exam if you want one within 21 days of your arraignment and within 7 days of today's date. So you understand that. Okay. So Mr. Taylor, how are you with your discovery? on that?
I have all the discovery.
Okay, what would you like to do then?
This I'm respectfully asking for an adjournment of the probable cause conference. I did speak with the prosecutor, and there's a possibility with me submitting a deviation letter that we to resolve this matter at the district level.
Okay, wonderful. Deviation adjournment.
Course available September 2nd at 9:30.
September the 2nd, 9:30 for another probable cause conference. And his bond is going to be continued. He just needs to sign his notice and then you're all set. Oh, before we do that, sir. Remember that 21 days, 7 days I told you, that time frame? We're going to be waiving that because your lawyer has requested an adjournment to see if he can get you a better deal for possibly a misdemeanor. So you don't mind waiving that time frame to allow him to do that? Okay, all right. That's a knowing voluntary waiver of that 21 7-day rule as well. Okay, now he's all set.
This one next. Thank you.
You ready? Case number 25S02195ASM, State of Michigan versus Bernard Barton.
Floor request for the people, Your Honor.
Good morning, Mr. I'm the program on behalf of Mr. Barton. Mr. Barton, could you state your name, please?
Yes, Bernard Barton.
Okay, Mr. Barton is on Zoom. And so
Yes.
let's see, we are here for a pre-trial today. This is on one kind of retail fraud, 2nd degree. So that is a misdemeanor that carries a maximum penalty because it is a 2nd degree. It'll carry up to 1 year in the county jail. And I think the fine is $2,000 maximum. And you have certainly a right to have a trial on the matter by judge or by jury with your lawyer representing you. So you understand that, sir?
Yes, ma'am.
Okay, so how would you like to proceed today?
Spoke to the prosecutor, I spoke to Mr. Barton. Mr. Barton wishes to plead guilty to this as charged, and we will ask for immediate sentence.
Okay, so Mr. Barton, you have spoken with your attorney and wish to waive your right to have any kind of trial in the matter, and you just wish to plead guilty as charged today. Understand that apparently there's no reduction in the charge. Is that correct?
Yes, ma'am.
All right, let's go over your constitutional rights. And if you understand your rights, all you need to do is say yes as we go over these rights together. And I'm going to put the rights form up on the screen as well. Can you see the screen?
Yes, please. Yes. Yes, I can.
Okay, good. So certainly you have a right, and I when I stop talking, if you need to read that form without listening to me, I'm going to give you a chance to read it too, okay? So, but you have a right to have a trial by judge or by jury with your lawyer, and you understand you're going to waive that right?
Yes.
And you also have the right to subpoena witnesses, which means you have the right to ask the court to order any witnesses to appear under subpoena to testify on your behalf. You understand you're waiving that?
Yes.
You also have a right to question through your lawyer any of these witnesses that might be brought against you at a trial. You understand you're waiving that?
Yes.
You have a right to testify on your own behalf. But if you choose not to testify, no one can hold it against you. So you understand you're waiving that?
Yes, ma'am.
You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt by the prosecution. You understand you're waiving that?
Yes.
You're on probation or parole status now, and you plead guilty today. Your plea might be considered a probation or parole violation. You understand that?
Yes.
All right, so now's the chance you get to read the advice of rights form since you're not in a position to sign it. And there's 12 paragraphs on the form. And let me know when you want me to scroll up, okay?
You can scroll up.
Okay, hold on. Let me see. Where's my, there it is.
When there is federal law, state prohibit you wish possession of. Okay. I've completely read.
Did you have any questions about anything on this form, sir?
No, ma'am, not at this time.
All right, understand that if I do accept your plea, you will not have a trial of any kind, and you're going to be giving up the rights that I went over and the ones that are on the form here.
Yes.
You also understand the potential penalties involved with this charge.
Yes, ma'am, I do.
And you looked at paragraph number 11 about any appellate rights that you might have, correct?
Yes.
And you still wish to plead guilty then to retail fraud, second degree.
Yes.
Has anybody forced or threatened you to make you give up your right to have a trial here?
No, ma'am.
Anybody promise you anything at all?
No, ma'am.
And you're pleading guilty here freely and voluntarily, is that correct?
Yes, it is.
Okay, so did this offense occur on or about May 31st, 2025 over at, okay, I recognize this address, 28800 Telegraph Road, which I know to be the Meyer store located at 12 Mile on Telegraph Road near 12 Mile in the city of Southfield. Is that correct?
Yes, ma'am.
All right. And so on that date, Meyer, was the store open to the public, offering merchandise for sale to the public?
Yes.
And did you take some merchandise offered for sale by Meyer without paying for it?
I proceeded to push merchandise that was in a basket that other merchandise had been purchased that was not paid for up under purchase paid. Yes.
Okay.
Yes.
So the short answer is you had some things you paid for in the basket, some things you didn't, and the
And
ones
other
that
things weren't. Correct.
and the ones you didn't pay for, you intended to steal. Is that correct?
Something along those lines, yes.
Well, no, it's got to be along those lines. What do you mean something along those lines?
Yes, it was merchandise. I had passed through the register and I was proceeding to exit the store with merchandise that was not purchased in the basket as I pushed it. Yes.
Okay, and so you intended to steal it, right?
Correct.
All right. And the value of that merchandise was how much? Do you know? Prosecutor know the value of the merchandise?
I do not, Your Honor.
It's a second degree, so I'm not sure what the basis of.
Has, the file, I don't know.
Okay, it's a ticket and it has no information on it.
We would stipulate to being, 200 to 1,000, I'm sorry.
Okay, so we're stipulating that it was, sir, you agree then that the merchandise was at least valued at $200 or more, but less than $1,000?
Very well correct.
All right, do you remember kind of sort of what it was that you didn't pay for so we can get an idea?
It was like some bathroom items. It wasn't much.
Okay. All right, but we know it's at least $200. Okay.
Correct. Correct.
All right. Did you have any permission from anyone at Meyer to walk out without scanning or paying for those other items?
No, ma'am.
Okay, people satisfied that factual basis?
I am Your Honor, go ahead.
Satisfied as well. Mr. Barton, did Meyer retrieve their stuff then?
Why do we care about that?
Yes.
Oh, okay. We could talk about that later. But okay, the plea is satisfied though, right?
Yes, sir.
Okay, then I'm gonna accept the plea, finding that it is freely, understandably, voluntarily, accurately, and knowingly made. Okay, so Meyer immediately was able to retrieve everything and got it all back.
Yes.
So you're not
Correct.
requesting restitution then?
No, Your Honor.
Okay,
Items were covered, then no.
okay.
Your Honor, Mr. If you can move to.
Yeah, I don't know anything about him, so yeah, you tell me.
As you can see, Mr. Barton is in Macomb County Jail.
Yeah, what's he there for?
He was sentenced on a R&O charge at circuit court.
For how long?
He's going to be released. It's not right here on the jail website. February 17th, 2027. He also too has holds. I'm not sure, Mr. Barton, have you handled any of your holds?
Yes, sir, I have. This is the only one that I still have current.
On the jail's website, it lists other holds, but let's see. 36th District Court, 17th District Court, 20th District Court, 23rd District Court in this state, but the informs that he handled everything else. But that is his scheduled release date, February 17th, 2027. So that's about 6 months. Okay.
Yeah, okay. Sir, what would you like to say about this and why did you do that?
I'm gonna be exact with you, ma'am. It was honestly, I took a friend there. He's legally blind. Both of us shared a basket and I didn't pay attention to, but I was the person that was pushing the basket through the exit doors. So I was the one that got charged with it. I'm already here. I'm tired of going through this. I'm ready to change my life and continue on with my life. So I'm ready to accept it and move on.
Well, okay. All right. So you're in custody. You're not going anywhere anytime soon, correct?
Anytime, so unfortunately.
Well, listen, you make good on the time, sir. You
Yes,
can
ma'am, I
spend
am.
time and just waste the time, or you could sit there and plan your life.
Yes.
And they give you a pad and they give you a pencil. If I were you, I would take the pad, draw a line down the center of it. On the left side, I would write every single thing that I would like to correct about my situation that's a wrong that I need to right. And then I would point an arrow after the first one to the right side of that line. And then I would list every single thing that I needed to do for that first issue to correct it or fix it.
Okay.
Then, that might be 2, 3, 4 pages or something, but it's a plan. And if you don't have a plan, you're spinning, you're going nowhere. So that's a plan. So let's just say, well, for example, if you wanted to get a job and that's something that you needed to do, then you need to write down on the other side, what are the steps to do? Well, am I going to go online and put in the applications? That might be step 1. Step 2 might be, I'm going to go to, 5 employers per week and put in an application, 1 a day. It might mean, let me enroll in school. Maybe I need to go back to community college or regular college to get something under my belt so that I can apply. Then you might say, well, how much does it cost? And can I get financial aid? Let me look into that. And then how many hours can I take consistent with my budget and my financial aid? And then what you do is you check off each thing that you've done or looked into. And then that way you're moving forward. That list should be evolving. It should be halfway live so that as you check things off, you've added things onto it. And in that way, you have changed your life. And if it means getting rid of some people that you're around, then get rid of them. If it means changing your own viewpoint to say, look, I know this is wrong and I don't need this stuff right now. I'm not doing it. You gotta work on you, and you gotta have a plan and able to do it. Because I believe that you are certainly able to be rehabilitated. You just haven't liked yourself enough to do it.
Okay.
So like yourself. You know what you got. You know what you got to offer. Everybody in the jail is not a horrible person. They just
Correct.
misdirected, misguided, haven't focused on things, maybe took the easy way. It didn't work. Maybe didn't have a lot of guidance when they were at home. It could be a number of factors. But at this age and this time is no time like now for you to take control of your life and your situation. So make the
Understood.
list. Pull the list out every day when you're there. Look at it, alter it, change it. Well, check off whatever you can check off while you're in custody, sir. So use your time effectively. So that when you get out, and let me tell you something, this year is going fast. So February will be here before you know it. Be ready when you step out of that jail. Be ready. Be focused. Be determined. Have your plan. Because if you don't, you're going to go back. You're going to do the same things. And what's the definition of insanity? Doing the same thing and expecting a different result. So don't go insane. Get your mind straight. And that's my advice to you. Okay. So this is what we're going to do. We're going to give you a concurrent jail sentence because we're not going to have to deal with no probation. So anything else you want to say?
Thank you so much.
All right, sir.
You have a great day.
Wait a minute. I didn't give you the sentence yet.
I'm listening. I'm still here.
All right. So you're getting out and let's see, this is only August. So September, October, November, December, January, that's 6 months. So what I'm going to do is give you a concurrent sentence. And this is going to be 4 months.
Okay.
So that'll be 120 days. And that'll be concurrent. And I don't know if you got a personal bond in this case, so we can give you some credit or not. Let me see. The original bond was, let's see, 720. It looks like $1,000 cash or surety. Did you ever post a bond? No?
No, they gave me a personal bond.
When did they give you a personal bond? Because I see cash or surety here.
Mr. Burr, I gave you a cash security bond. That's what my records show.
So you got credit from the date she gave you this arraignment date, which was July 20th. Okay. So we're gonna give you let's see, this is $24 days.
Okay.
And I'm gonna waive any warrant fee. And I'm not going to do any fines and costs of any kind. So 120 days credit for 24, that completes the matter.
Okay.
Remember what I said, I expect some results from you.
Understood, Ms. Johnson.
All right, good luck.
Thank you.
All right, you're welcome, and thank you, counsel.
Bye-bye.
All right. This is case number 23S01133SD, State of Michigan versus Gary Griffin. Okay, Mr. Gray, good morning. Okay, Mr. Griffin, let me find your matter. Jessica. Whoop. Oh, I see it. I'm just saying, I can't see, so what page? Found it. Okay, so Mr. Griffin, you're here for a probation violation. Operating while intoxicated. Maximum penalty on that charge could be up to 93 days in jail. You certainly have a right to have a full violation hearing with counsel representing you. And at that hearing, the burden of proving the violation would be on the prosecutor. They have to prove it by what we call the preponderance of the evidence. So that means all things considered, the greater weight of the evidence has to tip the scale from balance at least 51 to 49%. So if it's tipped that way to convince me that you in fact are in violation of your probation in the manner that's being claimed here. So if you choose to waive your right to the hearing to just plead guilty, or if you have a hearing and you're found guilty, that's when the penalties come into play. So you understand?
Yes.
All right, so let's see what the allegations are. All right. So it goes back to August 13th of 2025, at which time it was alleged that you had failed to report to probation as directed, failed to register for your alcohol drug screens, did not provide proof of attendance at AA meetings, and did not register for substance abuse treatment. So those are the allegations. How would he like to proceed, Ms. McGee?
We discussed the allegations as well as his rights, and understanding that he does have that right to contest these allegations, or the Mr. Griffin wants to admit to.
All right, is that right, Mr. Griffin?
Yes.
Has anyone forced or threatened you to make you give up your right to have a hearing here? Anyone promised anything to you? You're waiving your right to have this hearing freely and voluntarily after you have spoken with your counsel? All right. So is it true then that you had, at least prior to August 13th of last year, you had not reported every time as directed, that you had not registered for your alcohol drug screens or for your substance abuse treatment, and that you did not provide proof of AA attendance?
Yes, ma'am.
Okay, so then that's sufficient basis for the violation. I will accept that plea, finding that it is freely and standing voluntarily and knowingly made. All right, so let's see. The recommendation here says, well, you came to your first appointment and then you just gave up. What happened?
I was battling a case in White Lake. I had heinous allegations against me from my girlfriend's mother against the kids. When I got out of jail, I was put on Tepe and I couldn't go home. I couldn't be around none of the kids. I had nowhere to live. And I was battling the case back and forth with White Lake. Came to my first appointment and I didn't have transportation or money for none of the classes. I didn't have none of that, and I was just, honestly, I was worried about trying to get home and back to my family. And that's where I'm at today.
Where are you at today?
In White Lake, back home with my family.
Okay.
I just got a job. I showed my probation officer a month ago. It's 6 minutes from my house. I get dropped off by my girlfriend, then she goes to work. I get there at 7, she's at 8, and then she picks me up after work and brings me directly back home. I have all of my kids, my mother, my girlfriend here. I have a lot of support. I haven't drove.
Your kids know what happened here while you're here? They know about the drinking? They know about the driving while drunk? Then,
You know,
so you've been very open and candid with them. And so you're trying to be a role model now to them, to tell them not to do what you did.
Yes. Over a year clean.
Good for you.
I've been since April of last year.
Have you gone to AA meetings?
I did 3 of them on virtual at St. United. I started those Fridays.
Okay, so you just started those. How have you managed to maintain your sobriety?
I chose myself to get clean. I wasn't forced to. It wasn't these terms. I've never had a drinking problem. If you look at, I had a pill problem. I had a rough couple years, and the last
How did you manage to stop that?
got expensive, and I chose not to. Once I got clean and back around kids working, that was better than drinking or staying out.
So you chose yourself. Okay.
I chose, I have to be around for them. None of them have a real father in their life. It's just me. And that's what I'm happy with.
Okay. Did you want to say anything? He said it all. Yeah, he said it all.
Said I have pretty much everything he just said, listed here that he has gotten himself into, and he's always called about substance in his counsel, and he's trying to put the past behind him and move forward. So we have to support adopt the recommendation, and extend his probation. We would ask that the $100 bond fee be waived so that he can concentrate on the $2,500 costs, the fines and costs that are associated with it.
No, he's gonna pay the vibe fee. Yes, sir.
Yeah, let me just, this is where doesn't.
Yeah.
When was it?
Sir, I don't know what this is a violation. I don't know what you were supposed to do and when. Your probation officer is in charge of all that. And all I can tell you is that doesn't change. You have to comply with all of that. Now, the AA meetings, you still got to do those. You can do those in person, which I actually prefer because I think you really make a good rapport with the people that you're in there with. But you can do some online if you wish to do that. But you got to make your counseling sessions and make the AA meetings and basically every single thing that you were supposed to do before, including the substance abuse treatment. People wish to be heard. $100 in violation costs. 7 days in the Southfield Work Program in lieu of any jail. So that means you sign up for the Southfield Work Program. There's a little daily fee. You'll do it for 7 days, and it's whatever they need done around the city that will assign you to do. You do that, you don't have any jail in this. If you miss it, you don't do it, then of course you're gonna owe me those days in jail. No deal, unless you get hit by a car or something, which we don't hope. All right, so basically you'll do that, you'll continue your probation, and we'll extend it. 15 months. And he will have oversight fees for the additional 15 months. And then you will complete all of your original terms and conditions. Okay, so you're gonna be all set. And we'll just add that $100 in on your balance, and you should have a payment plan with your probation officer to get everything paid over time. Looks like you owe $2,580 currently.
I pay that off before 15 months.
Then you don't owe it. And let me tell you, if you finish every single thing and you believe you benefited after half of that time has passed, you could request to be early released. So we don't know what we're gonna do because we really got to look at you carefully since you violated once. But we could still release you, whether you've got it paid or not, and put you on a payment plan. But yeah, if you get it paid for sure, you could request it if everything else is done. Okay. All right, good luck, sir.
Thank you.
Mm-hmm. Okay, so this is case number 26S00456SD, State of Michigan versus Rashawn McCarthy.
Your Honor, Laura Kamaj will be at the people.
Thank you. Far as the people to a one standing for here to.
All right, and Mr. McCarthy apparently has a civil infraction too, which is case number 26SO00902AOI. And this is, let's see, people of the city of Southfield versus Rashawn McCarthy. Okay, what's your name? Okay, Mr. McCarthy, so you're here with counsel. Oh, Mr. Smith, how you doing? Good. Yeah, you too. He's standing in for Mr. Janadia. You have a problem with that? Okay, good. All right, so today is a pretrial date for operating while intoxicated, second offense. And then what you have on the civil infraction is a disobeying a traffic control device as well. Now that's set for formal hearing, but the other matter is set for pretrial, and you certainly have a right to have a trial on the matter by judge or by jury with counsel representing you, and you understand that. So last time we were actually here was June. And it says we adjourned it to review some discovery and to pursue possible options. So not sure what the options were, not sure how it was pursued. Do you have any idea, Mr. Smith?
Yes, Judge, what's happened, he has some appointment on Thursday with Roseville, the drug court is If people submit an application, pay a $200 application fee and meet with their officer. And if he's accepted, then I will email the results that acceptance letter back to the prosecutor. And then we can go forward.
Yeah, because we're gonna have to have all the paperwork, memorandum of understanding and all that. Okay,
Just request counsel to send that over to me before the next hearing date. Appreciate that.
Yes.
will we be seeing you next time, Mr. Lindley or Mr. Janady?
Yes.
Okay. So we'll email acceptance to prosecutor. And you also are going to be in charge of getting all of that. If he ends up being accepted and he ends up doing a plea here, you have to get all that to our probation department so that they can write up the report for that. All right, but let's see if he gets in first. All right, so you wish to have an adjournment for that purpose?
Yes.
I'm looking over there. I don't see the bun. So all I can see is your bun. He's got an appointment this Thursday to see if he can get into a drug court. So I'd say, a couple weeks.
Court's available September 9th at 9:30.
Yes.
Is that good? Okay. 9/9/26 at 1:30. What I check one? 9:30. Okay. So we got 9:30 now. On September the 9th, this will be for another pre-trial. We'll go ahead and continue his bond. I do have a pretrial services report. Says he did take a PBT on August 1st. It says the photo. What are you doing with the photo part?
That must be an error on their end. I wasn't aware.
We had a couple people that photo was declined for whatever reason. I don't know what's going on with that.
Every 4 times when it was accepted, so I'm not sure the second I can test, so I was not aware. I would have just took another test.
How many drug tests have you done?
I said like 4 or 5. I'm not sure.
What drugs do you do?
Is it a recommendation that he be reduced from 5 to 3 times a day? And that the drug tests be eliminated. This was drunk driving with alcohol and
Sorry. Sorry. I'm sorry.
Feel like I'm not in trouble in my life up here. Okay. All right. So, Mr. McCarthy, I'm going to, let's see, I'm going to adjourn this for you to look into eligibility. And I asked about the drug testing because I'm going to discontinue that. I don't know about reducing his, I don't see anything in this report that says to reduce the number of times that he's supposed to test on the sober rate. So I'm not going to do that. Oh, this says reduce it. Just way down here. Okay, let me see. I'm going to do an amended form on the bond. So, these late tests that we've had for when you test late, don't do that. Because if I reduce the number of times, I'm going to expect it all going to be done on time, not within 30 minutes, because I don't know if somebody told you that, that's considered late. So you got to do it right on time. Yeah, because all of these have been late, an hour late. So I'm going to do it on good faith, but I will reinstate that if you keep being late. So what I'm going to do is keep the pretrial services supervision, of course. No possession or consumption of alcohol or drugs without a prescription. We will then submit to testing, and I'll have SoberLink decrease to 3 blows daily. Discontinue drug testing. And I'm going to make a note that but we're going to increase it if there are late tests. Okay, so this should do it for today. We'll see you back on September the 9th. Here's the bond form for him to sign.
Guys, I did want to be heard as it relates to the drug testing. I know the court already ruled on that. He's continuing the drug testing. I would ask if the court would consider random drug testing in this situation.
Why? There's no, and this is what pretrial services is doing. We're trying not to overburden people, overtax people, paying money if they don't seem to have an issue. So he has been testing normally with no drugs. So why do we want to keep testing?
I understand, Your Honor. I just know that a lot of times with situations like this, when somebody can't drink, they tend to go to drugs, and if they're not being tested for it, that's why the people are requesting random drug testing.
They're not going to do that. No. Now, if you come back with some evidence, you've done some drugs, then I'm gonna put it back on.
Your Honor, I one question. With the test, like sometimes I blow right on the directed times, and it take like 2 minutes or so for it to send. Is that acceptable?
That's fine. I'm talking like it's an hour late. Yeah, no, if it's within 5 or 10 minutes, that should be fine. Especially if you blow on time and it takes processing time, that's understandable.
Place, are they gonna give me different times? Like what the times since you going from 5 to 3? I had like set times that I would love it.
I would assume so. What you need to do is call Linda Barna, who is your pretrial supervision case manager. Let her know that the court took your suggestion, reduced it to 3 blows a day, and you want to know how is that going to be scheduled. If she can tell you, it could be random and they could just alert you. It's the last minute. I don't know how they're going to do that. And then, of course, she will get the same order you got that says it's discontinued as far as your drug testing is concerned.
Yeah, but it's when you even test today.
Yeah, go. And if it's late, just remind me, because they might send me an order saying it's been, you were there or you tested late. So just remind me that you're in court. That's not a problem. Yeah, okay. You're all set.
Thank you. Thanks.
All right. Good seeing you, Mr. Smith. Looking forward to seeing you again on this matter. Is this the next matter? The next 10 matters? Here we go. Take the stack. Okay, this is case number 26S00199 SM State of Michigan versus Daisyon Sparks. Daisyon Sparks.
Good morning, Your Honor. Marsha, we have people.
All righty. Mr. Baldwin. And what is your name, sir? All right.
Hi, Mike Owen, P 6541, on behalf of this, it's time set for the bench trial.
Well, this is a trial on one count of larceny, $200 or more, but less than $1,000. People prepared to proceed.
Your Honor, if I may, address the gallery, if I have a witness.
Absolutely.
Thank you. Is there a Caleb Gillians in the courtroom? I did receive confirmations from, the detective that Ms. Gillians is not out in the hallway either, Judge. Without further, people cannot proceed at trial today.
Judge, the defense counsel is ready, willing, and able to proceed with the bench trial. Based upon representations made by our assistant prosecuting attorney, I'm asking the court to dismiss this case without prejudice. I also want to note that the complaining witness, based on information and belief, has her phone, which was the key issue. So
Allegedly, he took the phone. So let's just say he took the phone. He gave it back. I don't know. I have no idea. That was
and she got it back.
Yeah. All right. So what we were here for today, sir, is to find out what, if anything, really happened here. So I don't really know anything about the case, only what the charge is. So what I can glean just from my superpowers, I guess, not knowing anything at this point, is that this is someone you know, y'all argued about something. You just took her phone for whatever reason, thought better of it, and then said, okay, here's your phone back. And now y'all are cool. That's just my thoughts. Not knowing a thing, which of course I would not have gone into the trial with any preconceived notion. I'll wait to hear. But now that you've told me what he's told me, I'm thinking maybe that is what happened. I don't know. I was waiting to hear and to see if the prosecutor could prove this beyond a reasonable doubt. So, but they can't prove anything. They can't prove you took it. So, because they have no witness. So I'm going to grant the motion. It's going to be a motion to dismiss. And it'll be a dismissal with what we call without prejudice, meaning that if they chose to, pursue this, they can track down the person who allegedly had the phone stolen and, get her here, and then we could start all over again. And that's on the discretion of the prosecutor, not me. So it might come back, but it's probably doubtful that it will, but I can't speak for them. What I can say is I know who does know what happened, and that's you, and that's that other person. So just use this dismissal as an opportunity to just move forward. If you think you did something, because you might not have done it. I don't know what you did or didn't do. But if you think you did do it somehow, then just see what you need to adjust. Maybe it's a matter of just dealing with whatever the controversy, if there was one, a little differently. Sitting down talking about things when you cooled off. I don't know. But just walk out of here a little bit more better off than you were when you came in. Okay, that's all I'm saying. And just, so that you never get yourself even charged with something where you have to go through this again. Okay, so I'm going to go ahead and dismiss the case because we do not have a witness.
And thank you for your words, Judge.
Okay. I don't know if I was wrong or not on my little speculation after the fact, but he said, okay, that's okay. As long as you're walking out of here like a new man with a new perspective, I'm good with that. Okay. And it might be that you need to change friends if that's the case too. You never know. But you make those decisions as you leave. And I am canceling your bond. I don't know if you've got any money, but I'm about to check and see if we owe you anything back. We do have $750 here. It was posted by somebody named Pierre Sparks. So she'll get that money back. We'll have it refunded, and then that's gonna finish the case. Good luck, sir. All right. Mhm. All right, case number 26-00488 FY, People State of Michigan versus Tony Davis.
Lord, Caution the people, Your Honor.
Good morning, Your Honor. Rebecca Roberts, praying on behalf of Tony Davis, who's also present by Zoom.
Yeah, Ms. Roberts, good morning. Good to see you.
Good to see you.
All right, and Mr. Tony Davis, tell us your name.
Tony Davis.
Okay, and Mr. Davis, you're here with your lawyer for, let's see, it's a false pretenses, $1,000 or more, but less than 20,000. And this is a probable cause conference date on that charge. So this is the date to determine how you want to proceed. Do you want to have a preliminary examination on the matter? Apparently, your first hearing in this matter was back on June the 16th. That was our first probable cause conference, again adjourned. I know I was out for a minute, but we did adjourn it at first for you to get some discovery. And it was over 400 pages, Ms. Roberts had said. So, and I'm not sure that we did waive the 21 days. Any objection to at least waiving that now due to discovery?
No objection, Your Honor. I think we did waive, but.
Okay, I must not have marked it. All right, so Ms. Roberts, you got everything? Did you have a chance to go through everything?
I did, Your Honor, and we are asking for an exam date.
All right, we need an exam, 400 pages. So how many witnesses does that translate to? Do we know?
2 or 3, Judge.
Okay. 2 or 3 witness exam then.
September 21st at 10 a.m.
September 21st at 10.
That works.
Okay, good. September 21st, 2026, 10 a.m. That'll be obviously in person for a preliminary exam. All right, sir. So Mr. Davis, you got to get here on September 21st at 10 a.m. for your preliminary examination. We are going to continue your bond until then.
Thank you, Your Honor.
Hey, good luck, sir. We'll see you back here then. And I guess, are we going to send him a notice?
Yes.
We'll send you a notice, sir, since you're not here to sign.
Thank you.
Okay. All right, Ms. Roberts, everything good with you right now? Anything else?
Good with me. Thank you very much.
Okay, we'll see you then. Bye-bye.
All right, bye-bye.
All right. Next, case number 26-00727, FY State of Michigan versus Demarius Nobles.
Good morning, Your Honor. Lord, Caution be at the control.
Good morning, Robert. May I please report? My name is Matt Savage, and I'm Mr. Noble.
All right, Mr. Nobles, you're here, and good morning, Mr. Savage. With counsel, and this is for a probable cause counsel conference as well. Looks like there are 2 counts here. Let me see if they're both the same. One count 1, unlawfully driving away an automobile, is 5 years and up to well, it doesn't tell me the fine here, but it does say your driver's license could be suspended for 1 year. Count 2 is an attempt unlawfully driving away a motor vehicle. So that would be up to 2.5 years as well, with a potential suspension of the driver's license. Count 3 is a misdemeanor. Operating while license suspended, revoked, or denied, carrying 93 days, $500 fine, and possible suspension of license again, and vehicle immobilization, and possible points. And so you have a right to have your preliminary exam on the 2 felony charges within 21 days of your arraignment and within 7 days of today's date. That misdemeanor suspended license is not the subject of the preliminary examination, but it will be just trailing along with it for trial or further disposition later on. So you understand those rights that you have? Okay, so let's see, Mr. Savage, since this looks like our first appearance, do you have all the discovery?
I have all the paper discovery. If there's any AV discovery, I did not receive that. I did receive a transcript of the initial interview with my client, so I would imagine there may be audio and or video of that. I don't necessarily need that for the preliminary exam, but at some point it would be nice to get it if it does exist.
All right, is there any other audio that you might have or video?
I do see some in the file, Judge. I'll make sure those get tendered to defense.
All right, do you want to look at that first, or you know what you want to do now?
No, Your Honor, based on the information I have, we still want to have a preliminary exam conducted. If I can get the AV before, that'd be great, but it's not necessary for me to change my mind.
All right, how many witnesses do we have here?
Say about 3, Judge.
3 witness exam,
Court's available September 23rd at 10 a.m.
September 23rd, good?
Yes, Your Honor, that's good. And I have explained to my client that there would be a good chance that this exam would be conducted after the 21 days and after the 7 days from today's date. And I'm 100% confident he understands that. He's prepared to waive that procedural requirement.
All right, sir. You understand that we're setting it out a little bit further than 21 days from your arraignment and 7 days from today's date, just due to scheduling and due to the fact we're trying to get some discovery that your lawyer doesn't necessarily need but would like to see. So you don't have any problem waiving that time frame. Okay, so that's a knowing voluntary waiver of that.
Change that to 2 p.m.
Yes, that's fine. 2 p.m.
Holidays.
Okay, that's a waiver, knowing voluntary waiver of the 21 7-day rule. And we'll change it to 2 o'clock. And Charles has already written the notification.
I'm sorry, Charles.
And Judge, is there a class I need to take to get some of those superpowers that you
I don't
that you
know.
have?
A little lightheartedness today. Yeah, a little lightheartedness. I don't really am either, so apparently I might have been wrong, but maybe right. Who knows?
I'm gonna get spot on, but.
Just getting ready on whatever we got next. So next is going to be case number 25SO00583 ASM. People say the Michigan versus Nyla Dodd.
Laura Kamaj, behalf of the people, Your Honor.
All right, and your name is?
Nyla Dodd.
And Ms. Dodd, let's see what you're here for today. It looks like that's a ticket. Let's see what it is. Oh, okay. So it looks like you're for pretrial on one kind of possession or use of tobacco by a minor. All right, so that would be like a 90-day misdemeanor with a $500 fine. And you also have a right to have a trial by judge or by jury on the charge with a lawyer to represent you. If you couldn't afford a lawyer, you like a lawyer, then we could certainly have someone appointed to represent you if you're eligible. So you understand that. Okay. So did you know how you want to proceed today? You can ask for a lawyer if you want. You could waive your right to a lawyer and talk to the prosecutor to see if she's going to offer you something. Or you could say, I want a trial, or any of those options. You want a lawyer? Okay. Give her the paperwork, please. Did they offer you one when you were arraigned? Okay. All right, we're going to get you to fill out the form. And if you remember the form, you need to make sure when it says address, don't only just put the street address, put the city, because that's the form the lawyer is going to get. So they need to know the city, zip code, all your email, your phone numbers, just so they can be able to contact you. Okay. And you can just write your name at the top of the form and I'll fill in the rest of it. And then I'm going to call you back once you've got everything filled in. Okay. All right. Next, Daniels.
Yeah, right.
Case number 23S00093SD, State of Michigan versus Deshaun Daniels.
Laura Kamaj, people, Your Honor.
Okay, Mr. Daniels, let's see what you're here for this morning is a probation violation hearing on one kind of operating while intoxicated, where the maximum penalty is up to 93 days in jail. You have a right to have a full violation hearing as to whether or not you're in violation of your probation in a manner that's being claimed by the probation department. You have a right to have that lawyer represent you at a hearing. If you'd like a lawyer and can't afford a lawyer, then we'd certainly get someone assigned to represent you. So you understand all that? Okay, you filled out a form asking for a lawyer. Now, let me just tell you what the allegations are, by the way, just so you know. If you didn't know, you should have received them at your house, but goes back to October 17th of 2023, and it was alleged that you tested positive for alcohol on September 25th, 2023 via an ETG test and then a confirmation test. And then you failed to report to your probation as scheduled. Oh, no, failed to report to scheduled alcohol and drug testing, September 30th, October 5th, and October the 13th of 2023. So those are the allegations. All right, so let's look at your form. All right, so you put the address, you didn't put the city. Yeah, it says it. You're not the only one. People just say address and they just feel like that's the street. But in reality, your address is the street and the city as well. So what city do you live in? Okay. And what's your zip code? Okay. All right. We got your email. We got your alternative phone, regular phone. You're on public assistance. You're not working right now. Okay, I'm going to sign this, finding you eligible. We're going to adjourn this violation hearing. For counsel to be assigned. Someone should contact you prior to the next date. So be ready to talk to them, get together anything you feel that's relevant to your compliance and show it to your lawyer. Okay. All right. What's the next date for this?
September 3rd at 1:30.
Okay, September the 3rd. 1:30 will be our next date.
At 1:30.
Okay, that's it.
Look at your screen share.
Huh? Oh. Thank you.
Ready on the next matter.
Case number 26BH009488 AST, State of Michigan versus Ramon Hanna.
Put on behalf of Mr. Hannah.
All right, and Mr.
We're waiting on the prosecutor. I think she stepped down. Your Honor.
Right back there. She can step down. I don't know.
Oh, okay, I see him.
Resolution, Your Honor. We have to wait.
Not really. Unless there's some question about it.
No.
Okay. All right, Mr. Hanna, tell us your name.
Ramon Hanna.
Okay, and so we're here for a operating while license suspended charge. That's a 93-day misdemeanor, $500 fine, driver's license, possible points and possible vehicle immobilization, potentially license suspensions. And you understand the charge, correct?
Yes, Your Honor.
And you also know you have a right to trial on the charge with your lawyer representing you. You understand all that?
Yes, Your Honor.
The lawyer says he's got a resolution here today. What is the resolution?
Your Honor, I spoke with the prosecutor. They're going to dismiss that original charge. And my client is going to be pleading responsible to an added count of impeding driver.
That is correct, Your Honor. Laura Crash for the people.
Okay, Ms. Kamaj, thank you. So, Mr. Hannah, you understand that you're waiving your right to have a trial on this original charge, and they're going to add a civil infraction, and it's impeding?
Yes.
Of impeding traffic, which you will be then pleading responsible to. It's a 0-point violation. It does not go on your driver's record, does not abstract.
Yes, Your Honor.
It does carry a fine though. Okay, so you're okay with that?
I'm okay with that, yes.
Does anybody forced or threaten you to make you give up your right to have a trial?
No, Your Honor.
Anybody promise anything other than what was just stated?
No, Your Honor.
And you're entering into this freely and voluntarily after speaking to your lawyer, is that correct?
Yes, Your Honor.
Okay, so did this matter occur? This would have been on or about June 30th, 2026 at 3:40 PM, where you're operating a Dodge Charger motor vehicle on Beverly Road near Auburn Street, which are highways open to vehicles, Village of Beverly Hills. Hello, Mr. Hannah?
Yes, Your Honor. Yes, Your Honor. That's correct.
Okay, thank you.
No
And
problem.
on that date and time when you were operating the vehicle, you wish to plead responsible to an added charge of impeding traffic?
Yes, Your Honor.
Okay. So I'm going to accept that plea of responsible to impeding traffic. I'm going to go ahead and dismiss the misdemeanor suspended license. Per the plea agreement. All right, he doesn't have any money posted, so there is a fine on the impeding, and that'll be $160. Do you have that today, or when will you have it?
Yeah, I have that. How do I make the payment for it?
Well, there is a way to pay it online. You'd have to call downstairs to the misdemeanor felony desk and ask them how you could get that paid. If you choose not to do it that way, we could give you time to come in and get it paid. And I do believe that there may be an extra little processing fee for a credit card payment.
Yes, I'll send. There's Mr. Hannah, there's a link I can send you where you can pay it online.
Okay, no problem. Thank you.
Okay. How much time do we want? Like a week? Just
a week.
Yeah, we'll give him a week just to firm it all up. So, sir, try to get that paid by next Wednesday, August the 19th.
I'll have it paid by the end of the day.
Okay, very good. All right, you're all set, Leo. As I said,
Introduce you to a colleague, Zoe Blanchard. She just took the bar exam and she's in training and I just wanted to introduce you.
are we still awaiting bar results?
Yeah, she just took the
To the July bar. Okay. And Zoe, what was your last name?
Blanchard.
Oh, Miss Blanchard, nice to meet you. Well, congratulations. Finishing law school is a very big feat. I can kind of remember it. It's been a long time.
It's all of our.
It happens quickly. It's like a wedding that you plan for all those years, and then it's over in the blink of your eye. But let's put well wishes out to you for, I think around October, those results come out sometime around there. So we're going to be giving you our best wishes for positive results in that. And you're in good hands there with Mr. Puda. He's got a good disposition. He's prepared. We've been knowing him for years. So I think he'll steer you in the right direction if you're interested in his type of practice. He does some of a little bit of everything. What is your interest?
Criminal defense.
Criminal defense for sure. Yeah, that's a good place to start. Yeah, it's a lot of fun. You meet some very good people that some folks are just in a bad bind and Some folks did it, some folks didn't do it, and it's your job to weed it all out and make that prosecutor live up to her burden of proof. So I hope that everything is successful with you, and nice to meet you. And come on back. I'm sure you can get on our list, once you get your P number.
Thank you.
What are they up to anyway?
I think,
P.
is it 8s or 9s?
It might be 9s. Ooh. I'm gonna tell you what mine is. It's old. But congratulations. Nice to meet you, Miss Blanchard. Okay. Bob, what are you doing? Fraternizing with the prosecutor. That's okay.
Thank you, Honor.
Okay.
Take care.
I'm pulling your leg over there. I said he's fraternizing with the prosecutor.
Ready on the next matter, Judge.
Okay. All right. So this is the file. If you want to take it down with them, they can.
Yeah.
Okay.
I'm keeping the prosecutor.
You got it in line. Good for you. This is case number 26S00352 FY. This is People State of Michigan versus Ernest Jernigan.
Good morning, Your Honor. Laura Flash on behalf of the people.
All right.
Good morning. Good afternoon, Judge. I'm happy, Mr. Jernigan, Attorney Nicholas North, PA 642. Mr. Jernigan, please state your full name, sir.
All right, Mr. Jernigan, there's no form with us. This is a sentencing here that we're prepared for. And let's see, it's a count of domestic violence, second offense. And so we took this plea back in May. And so we're here today to firm up the sentencing, and we have a pre-sentence report. Did you have a chance to review it with your client, and is it accurate, Mr. North?
I did have a chance to review it, and yes, Your Honor, with Mr. Jernigan, yes, Your Honor, it is accurate.
Okay. Okay. Got a lot of older things on his record.
Full accountability for his actions. There was some drinking going on that day, which is why, once we're not objecting to the alcohol or drug treatment either, because obviously that will again help him. He's committed to doing things that he knows will help him and improve, his behavior, as well as he's committed to being a better husband. Your Honor, I would like to just say Mr. Jernigan has been on tether and been out on bond. He hasn't violated, he's been passing all his drug and alcohol tests. He hasn't, communicated or violated with his wife or violated the tether provision at all. Which is why at this point we are asking for the tether to be removed. So that way he can, have freedom of movement, and also, there's some restraint on his leg, which I believe he was shot in his leg a few years ago. So I know he's got bad nerves in his leg. So he's in constant pain when it comes to that. Your Honor, we're also asking that the no contact provision be lifted to no assaultive contact, and that any violation of that would obviously result in.
I don't do that without her.
You don't do that without.
Okay, what I'll do is I'm gonna get him in whatever he's gonna get started in. She'll have to contact the court if she wants some contact. And then I'm gonna refer her to Haven to make sure they do a little assessment to make sure she's not feeling pushed or threatened in any way. She has a survival plan in place if she does tend to feel that way. And then we'll have a hearing. We'll come back with him. We'll come back with her. You can come back if you want to. You don't have to. And then we'll make a determination if the no contact should be lifted. Not saying no, I'm just saying that's my process.
I just would like the court to take into account that financially he is essentially destitute. He was living with his wife at the time, but now he's living on his, I think, sleeping and living in his brother's home and on his couch. He's almost homeless. So I just would like the court to just take that into an account when handing down sentencing today. I understand the court's process and I understand the procedure, and if he will follow that procedure and that procedure will be followed, absolutely. But once again, that I was just asking for the no contact to be lifted to no assaultive contact, but I absolutely understand what the court has just stated. We're also asking that the court defer from the probation term a little, and instead of 24 months, we make it 1 year.
Why would I do that? He's already got one prior aggravated domestic violence on his record. Why would I shorten? This is an opportunity for him to rehabilitate.
Not charged with that, Your Honor. That's on my file. No charges not pressed against me on the case.
Why does this say you pled guilty on November 15th of 2006 per the lien, and you got sentenced to 15 days in jail? That is totally inconsistent with what you said, that there were never any charges pressed.
The reason why we're asking for the 24 months to be instead swapped with 1 year is because during the pendency of the case, he's been doing everything he's supposed to do. You know, he hasn't had any contact. He's been passing his test. He's been doing what he's supposed to do. Essentially, that he can be trusted to have a lower term of probation. We understand that by statute, he can get off probation early if he does everything he's supposed to.
Not on a DV, he cannot.
Not on DV.
No.
Okay. Understood. Well, once again, Judge, you know, I understand that there are reasons to not lower that probation term. I understand that, but I will also, balance those with the reasons to lower the probation term. And that those reasons being that during the pendency of the case, he's been doing everything he's supposed to do, even considering all the adjournments that we've had to do. You know, it was adjourned a month out from last month, still no violations, still passing all his tests. Even though he can't afford it, he's still paying for all his tests. Even though he's almost homeless, he's still, abiding with the court orders. And that's why we're asking you to lower the 24 months to at least a year.
Okay. Well, I'm going to ask you, sir, what you would like to state to the court before I pass sentence and before I hit for the prosecutor. I do see, I'm looking at your criminal history record. I think that's 37th District Court. I think that's Plymouth. It may cover some other little jurisdictions, but it says November 15th, 2006, misdemeanor domestic violence aggravated, pled guilty, sentenced to 15 days in jail. And then someone wrote here, victim deceased from cancer. Does that ring a bell? So you remember this now? Okay. All right. So he's got that one.
Take accountability for my actions. Very sorry. Never happen again.
You recall it, right?
I do, I treasure my freedom. And I do, the responsibility, but not to hurt nobody, and right. That would never happen again.
Okay. It happened once before.
It never happened again. I'm like 10 years ago.
20. Almost, yeah.
So
really no threat.
Here's the difference though. Should never happen ever. 20 years ago, this should not be on your record. One of the things that you kind of learn in life as you live, Mr. Jernigan, is that you can't control nobody else. You can only control yourself, how you react, what you do, what your expectations are. And if you got somebody that's not meeting your expectations, leave them, get rid of them, or talk about what your expectations are, how they're not meeting them, and see if you guys can come to a happy medium. You can't beat nobody into submission like that. You can scare them, but ultimately they're gonna get some courage at some point and leave unless you kill them.
Walk away or run away.
You know, and that's
Away from that situation.
that's what you should do. And you got to learn. And I know people's experiences are different. And some people can do things very easily, walk away, control their behavior, let things roll off their head and saying, you know what, that's not worth it. Other people react in 2 seconds and want to fight and cause a problem.
I'm supposed to think first.
Absolutely.
Don't react in that kind of way.
Exactly. And these are some of the things you'll probably learn and will be reinforced to you. The only question I've got, since you seem to understand this, is how did this happen now? As of 4/17 of 2026, with your wife, who it says here that you've been married to, you got 3 children, and you've been married to your wife, how long? 18 years. Now, either this is a one-time aberration with her, or it's not. And it says you have had the police called before, but it was just verbal.
I walked away then, so I do know how to walk away.
So what will cause you to do this now?
And I should have had, I made a bold decision. But
And then you have to say, what is the underlying problem that the police are even being called for so many verbal disputes? You all don't communicate well. I'm not saying you got to agree on everything. People don't. Different experiences, different backgrounds, different expectations. But when you got somebody that you're living with, married to, whatever, you got to learn how to mold those expectations into something you can both agree upon to do or to expect. And arguing about it doesn't fix anything, because what happens in an argument, people take the defensive posture. Nobody's really listening to what the other one is saying. They're all ready to defend it, fight it, argue it, hit below the belt, whatever they got to do. And then when you're done, nothing's solved. You got the same problem. So and maybe a day or two you cool off, you don't really discuss it. Life goes back somewhat normal. And you can't. It's going to be the same problem.
So comes right back in your mind again.
So the question to you is, how do we get you, because that's what the whole 2 years of probation that's been recommended is for, is to rehabilitate your mind, get you to the point where you take alternative measures. You know, and have you gone to counseling with your wife when you were in the same household? No, that's a problem. Because sometimes you need a mediator. Sometimes somebody to just put you on the right path to communication. Doesn't mean they're going to solve all your problems. Some counselors, that's not what their role is. The role is to be a mediator and to put you guys in a better place to be able to solve your own problems. Because I can tell you, if you sat down with her before all of this thing happened and you wrote out a contract between yourselves and you said, hey, we're never going to go to bed angry. We're not going to holler at each other. We're not going to pinpoint our biggest weaknesses when we're mad to each other. The person who's the most angry about the situation is going to be talking in a very civil manner, and the other person's going to listen. Doesn't have to agree. They're just going to listen and validate your feelings. Oh, I understand. I didn't know that caused you to feel that way. Oh, I understand that behavior, whatever I did, that it ticked you off. I didn't know that. Let's see what we can do together to solve that. I'm willing to. That's what a listener does. He or she listens, validates the fact, even if they didn't know it and didn't agree with it, they validate the fact that the other person had those feelings. That's all somebody with feelings and anger wants, is to know that they were heard. Not necessarily that they have to be right, but they were heard. I feel this way. You can't take that away from me. And you can say, I didn't do that. That's not the answer. The answer would be, I didn't know that my actions made you feel that way. You can apologize for that. I'm going to do better. What can I do to work with you to make that better? And that can work for any problem. Either you're going to deal with the problem head on, or you're going to divorce and leave. And that's what we got to get you to, where you never overreact like that. Because I guarantee if you had that contract, you both would hold each other accountable to it. And that way, you might be more successful in your disagreements and being able to come to a conclusion. Even if you walked away for a day and came back and still honored the contract and sat down and talked about it that way with a listener and a talker. And then you talk together after that occurs and figure it out. It's not as hard as it seems, but it is if you got all kind of emotion in it at the time that the incident is happening. That's not going to work. So you sound good, like you know what you need to do. You know it's a bad cycle. You know you got to leave, calm down, and that you're either going to work on something or you're not.
You can move somewhere else.
And you got 18 years into this. And I don't know how many of those 18 you all been doing this, but you got to go into it with a fresh perspective.
This level.
Just
verbal, and now we'll walk away.
Okay, but now why do we got to even have the verbal? That could be a conversation. I'm not saying the dispute should go away. You got a dispute, you got one.
Or to resolve it a better way.
Yes. All that verbal back and forth and everybody angry and you done called a name or two and she did too. That didn't do anything. No. It just piles on. See, the love is always there. It's at the bottom. And it gets buried over years of this arguing back and forth, name calling, dispute. And so you try to dig down, you can't even get to it. It's there. You want to find it, but you can't. And she can't either. So it gets to a point you don't like each other and you forgot you love each other. So you got to work this out. I think your mindset is ready. You just need some tools. You need some tools. And that's what you're going to do. So prosecutor want to be heard on this?
Yes, Your Honor, I did want to indicate for the record that there was a Killebrew agreement to no upfront jail in this matter. I would ask that the court adopt the recommendation by probation. I do find that I do believe that it's appropriate. Additionally, I did speak with a victim in this case. She indicated to me that she does not wish to appear for sentencing or make a statement. However, she wanted me to indicate to the court that she loves her husband and wants him home. I understand that defense is requesting removal of the tether, as well as amending the no contact order to a no assaultive contact order. I would object to the amendment of that order, Judge, given that I believe it had already been addressed on the prior court hearing, but there had been a jail call previously back in April that was tendered to defense, in which the defendant told the victim not to talk to police. So as the court already indicated, having her speak, I believe would be the other path here.
Yeah, that's what I'm going to do. You know what, sir? If I take that tether off, I would have to trust you not to go over there. And I'm not so sure you wouldn't go over there.
Let's Your man of it.
Hmm?
I do believe that you can trust him to not go there. The reason being, for one, he hasn't had any contact since this jail.
Well, we watching him too. We got tether on him.
That's true. I understand. I completely understand what you're saying. It makes sense, right? Like, how do we make sure that he doesn't go over there if he's not on tether? I understand. But what I'm saying is, I think that based on his compliance, his general compliance, since he's been out of jail, he hasn't, this jail call was made in jail when he was, feeling really bad. He hadn't been incarcerated in a long time before then. I do think that just his mind state in jail, which is honestly scientifically established, his mind state in jail was just something different as it is when he's out. He's been out, he hasn't spoken to her for months. And even though he hasn't spoken to her for months, as the prosecutor just stated, she does love her husband. So I do believe that you can trust him to not speak to her, because he already knows that if he does, he will be incarcerated again. So, or can be, as a violation of probation. And I know he's not trying to come back to court.
Okay. Well, obviously, we need some rehabilitation here. And that's the goal in all of this, is to rehabilitate him so that he can have a successful marriage, because, the way you guys are going, it's not healthy. It's just.
He's getting ready to move. I ain't gonna have no place to stay.
Where's your brother moving? Where's your brother moving?
Getting ready to move back to Ohio.
So
I wouldn't have nowhere to stay.
You just that you can't stay anywhere. No, no other person in the whole universe other than your wife. Okay. Well, sir, nobody thinks of the ramifications when they're doing the deed. This is just a ramification of it. You can't expect to allegedly, and in this case, we know you did because you pled to it. You can't assault anybody and expect it, business as usual. I still get to see him. I still get to stay around him. It's the exact opposite. Not only in this court, just about in every court you're going to go in. So the fact that you have a place to stay is not really my most major concern. My most major concern is the person you assaulted and getting them straight, making sure they have no fears, no issues, and then rehabilitating you so that I can try to get you both back together. But that's not a given thing. Rehabilitation is a slow process, and you got to want it and you got to work on it. There's no way you're going back over there in my courtroom without having gotten into some of the classes, being able to explain to me some of the things you did today, but with a little bit more insight into it. I want this to be successful for you and for her. I don't want no domestic violence third offense. I want felonies. I don't want to see you again in any kind of way on this kind of a thing. I want you to say, boy, it took me 2 cases like this, but I got it together and we're good now. I want this to be successful. She does too. And you're not going to be successful unless you start to focus on you first and then you and her. Because if you don't focus on you, then you and her is not going to work. So that is my prime goal in keeping you apart, helping you not to pick up another case, because I'm telling you what I know. I've seen numerous times people come back and they got another domestic violence case because they did what? They went back over there and they weren't supposed to go over there and they did it anyway. And sure enough, the police is called. They got another case. Do you really want to be that person, or do you just want to find a place to stay until we can get this thing going so that this doesn't happen?
I'm sorry, but he'll make it work, Your Honor. And if the process that you already laid out about how
it's a very fair process.
It is,
and it's not like it takes forever to get there, sir. You could get on probation today. You could get into some classes in the next few weeks. You might be able to come back here in another 8 weeks and say, look, I've taken X amount of classes. This is what I see. She might be here saying, you know what, I haven't talked to him, but